It doesn't help her. Oh. She's on her way. She's on her way.
Thank you, everyone. Please be seated. Okay, good morning, everybody. My name is Commissioner Hughes. This is the 8 a.m. initial appearance calendar for Saturday, March 15th. The court's orders for the taking of DNA samples and fingerprints issued on the first calendar of March will apply to the hearings on this calendar. As we get started in here this morning, I will call each of you into the courtroom one at a time. I'll ask one of you to stand behind this gray podium here in front of me in the courtroom. I'll ask the next two people I intend to call into the courtroom to have a seat in the two chairs right inside this door. I think there's two chairs right there facing all of you. So that's how we'll proceed through this calendar. Please listen for your name to be called. I know it seems kind of weird to do this whole move from one chair to the other, from that chair into the courtroom, but I promise you all it will make this calendar move much quicker. So if you'll please listen for your name and move through the chairs as I call your name, I would appreciate it, and I'm sure everybody else that wants to get out of this room would too. Once you work your way into the courtroom and you're behind the podium, the first thing I will do is ask you to state your full name and date of birth. Then I will explain to you why you're here this morning. We'll talk about whether you qualify for a court-appointed lawyer. Those lawyers are sometimes called public defenders. If you do not qualify for a public defender, you have the right to hire a lawyer to represent you and be present in any criminal proceedings. After we talk about whether you qualify for a court-appointed lawyer, I will give you the next court hearing dates and times that you'll be required to attend after this court hearing this morning. The last thing we'll do while you're in the courtroom is talk about whether you are legally eligible for release from custody. If you are, we'll talk about on what terms and conditions you could be released. In addition to that right to the assistance of counsel, you all also have the right to remain silent. These are recorded criminal proceedings. That means anything that you do choose to say in the courtroom this morning will be preserved on the recording, and it can be used against you at any point down the line in these proceedings. Whether or not you qualify for a court-appointed lawyer, there will not be a lawyer in the courtroom this morning for your defense. Because you won't have a lawyer representing you in here this morning, and because anything that you say could be used against you, I will strongly caution all of you against making any statements regarding the facts about why you're here. I encourage all of you to save any statements, questions, comments that you might want to make about the facts of your case for a hearing where you have a lawyer present to talk to about that before you make any statements that will be on the record that you can't take back. Last thing I'll tell you before we get started is that all of the information I give you while you're standing in the courtroom will be contained in a written document called a release order. When you're done in here and you step back into the room that you're in right now, the officers in the courtroom will hand you a copy of that document. So please don't feel like you need to memorize the information we go through in the courtroom, but please keep that paperwork you get with you wherever you go from here this morning, because like I said, in that paperwork will be all the information you got while you were in the courtroom. All right, let's go ahead and get started. Can I please have Servino Lopez all the way into the courtroom behind the gray podium? Kayla Robinson, if you would please work your way to the first chair inside the door. Alexander Moharo, if I could ask you to work your way to the second chair.
In the chair, ma'am.
Right there, yep. Turn around, have a seat. Okay. Can I have your name and date of birth, please?
Servino Otero Molina Lopez, 1/10/1999.
Thank you very much. Mr. Lopez. You are here on two different matters. The first matter that you're here on is allegations of new charges. Those allegations are one count of discharging a firearm at a non-residence, that is a Class 3 felony. 2 counts of possession of a weapon by a prohibited person, those are both Class 4 felonies. And 1 count of disorderly conduct involving weapons, that's a Class 6 felony. I have found probable cause to support those new allegations, and I have appointed a lawyer to defend you. Your next court hearings on the new charges will be a status conference March 20th and then a preliminary hearing March 24th. They will both be at 8:30 in the Superior Court downtown. On those new allegations, I have imposed a $250,000 secured appearance bond. The second matter that you're here on is a probation violation allegation. In that case, the allegation is that those new charges are a violation of Term 1 of your probation. I've also appointed a lawyer to represent you in the probation proceedings. Your next court hearing in the probation matter will be a revocation arraignment. It will be March 21st at 8:30 in the Superior Court downtown. On that probation matter, you are not eligible for release on bond. That means you will be held in custody without bail, at least until you see the probation judge on March 21st. Because you will not be eligible for release at least until after that hearing on the 21st, I encourage you to wait until you go to that hearing before attempting to post a bond on the new charges. Do you understand that information?
Yes.
Okay, thank you, Mr. Lopez. I do think we need to reprint one of those. Will you reprint number 1? I had to make a change to one of your papers, so we'll reprint it, swap it out, and make sure that all the information in that is correct. So go ahead and step back to your left, and we'll bring that out to you shortly. Thank you, Mr. Lopez. Kayla Robinson, if you would please work your way into the courtroom. Dennis Kozamihaloglu, if you would work your way to the second chair, please. Can I have your name and date of birth, please?
Kayla Danae Robinson, 110-2000.
Okay, thanks so much. And Ms. Robinson, can you take your hood down while you're standing at the podium, please? Thank you. Okay, you are here on 3 different matters. The first 2 matters you're here on are both bench warrants issued by the court when you failed to appear at hearing. One of them was a probation revocation arraignment hearing. The other was a status conference in an existing felony drug case. In both of those cases, you already have a lawyer assigned to defend you. Your next court hearing will be, in the probation case, it's two probation cases. So you're here on 4 total matters. 2 bench warrants issued when you failed to appear at probation hearings. 1 bench warrant when you failed to appear on that existing felony drug case. In the 2 probation cases, you do have a lawyer assigned to you. Your next hearing in those 2 cases will be a new revocation arraignment hearing March 21st at 8:30. On each of the probation warrants, you have a $250 secured appearance bond. On the existing felony warrant, your next court hearings will be a new status conference the 20th and then a preliminary hearing the 24th, also at 8:30 downtown. On that existing felony warrant, you have a $500 secured appearance bond. So $1,000 total in monetary bonds. The last matter you're here on is allegations of new charges. Those allegations are 1 count of narcotic drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. I did find probable cause to support those new allegations, and I've appointed a lawyer to defend you against them. Your next court hearings on those new allegations will in part be the same as your hearings on the existing felony drug case. So you will have a status conference on the 20th and a preliminary hearing the 24th. Those are the 2 hearings that will be the same on both of those cases. The difference will be on the new allegations. Because they are felony offenses alleged to have been committed while you were on release in that existing felony case, you are not eligible for release on bond. That's on those new charges. So on those new charges, you will be held in custody without bail at least until an evidentiary hearing is held. That hearing will be March 21st at 1:30 in the afternoon. So you'll have your probation hearings the 21st in the morning, that evidentiary hearing in the afternoon on the 21st. Because you will not be eligible for release on bond at least until the afternoon of the 21st, I encourage you to wait at least until you go to that hearing before attempting to post any of those monetary bonds. Do you understand that information?
Yes.
Okay, thank you, Ms. Robinson. You can step back to your left. Alexander Moharo, if you would please work your way into the courtroom. Eric Cavendier, if you'd work your way to the second chair, please. Can I have your name and date of birth, please, sir?
Alexander Moharo, May 26, 2005.
Thank you, Mr. Moharo. You are here on allegations of new charges. The allegations against you are 1 count of narcotic drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 20th, and then a preliminary hearing the 24th. They'll both be at 8:30 in the Superior Court downtown. Because these are felony allegations alleged to have been committed while you were on pretrial release in a different felony case, you are not eligible for release on bond. You will be held in custody without bail, at least until an evidentiary hearing is held. That hearing will be March 21st at 1:30 in the afternoon. Between now and that hearing on the 21st, you will be held without bond. Do you understand that information?
Yes, ma'am.
Okay, thank you, Mr. Moharo. You can step back to your left. Dennis Kozamihaloglu, if you would work your way into the courtroom, please. Bobby Jones, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please, sir?
Dennis Kozamihaloglu, 11194.
Thank you very much, sir. You are here on 4 different matters. The first matter that you're here on is allegations of new charges. Those allegations are 1 count of narcotic drug possession for sale, 1 count of dangerous drug possession for sale, those are both Class 2 felonies, and 1 count of use of an electronic communication device in a drug transaction, that's a Class 4 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings on those new allegations will be a status conference March 20th, and then a preliminary hearing March 24th. They will both be at 8:30 in the Superior Court downtown. On those new allegations, I have imposed a $25,000 cash-only bond. The other 3 matters you're here on are all probation violation warrants. In all 3 of those cases, petitions to revoke your probation have been filed. They all allege that you have violated terms 3, 5, and 15 of your probation. I have appointed a lawyer to represent you in all 3 of those probation cases. Your next court hearing in each of those matters will be a revocation arraignment hearing March 21st. It'll be at 8:30 in the probation court downtown. On all 3 of those probation warrants, you are not eligible for release on bond. That means you will be held in custody without bail, at least until you see the probation judge on March 21st. Because of that, I encourage you not yet to try to post your bond on the new charges. I encourage you to wait until after you see the probation judge on the 21st. Do you understand that information?
Yeah.
Okay, thank you, sir. Eric Cavendier, to the podium in the courtroom, please. Brian Fruler, if you would work your way to the second chair, please. Can I have your name and date of birth, please?
Hi, Eric Cavender, September 9th, 1991.
Thank you very much. It's pronounced Cavender?
Yes.
Okay,
correct.
thank you, Mr. Cavender. You are here on a grand jury warrant. A state grand jury was convened and found probable cause to return an indictment against you. In this case, that indictment contains 1 count. It is unlawful flight from a law enforcement vehicle, a Class 5 felony. The grand jury warrant alleges that was committed October 31st of 2024. I have appointed a lawyer to defend you in that case. Your next court hearing will be an arraignment hearing March 21st. It'll be at 8:30 in the Superior Court downtown. And on that warrant, you have a $75,000 secured appearance bond. Secured appearance means that you can use a bonding company to post that if you choose to. If you do post that bond and you are released from custody, you cannot operate a motor vehicle if you don't have a valid driver's license. Do you understand those conditions?
I do have a question.
Sure.
I have another case where I do have a pro bono lawyer.
Okay.
Would that be the same lawyer that will be assigned in this case?
Potentially. So when you say pro bono lawyer, is it a pro bono lawyer that was appointed or arranged to represent you through the court?
Yes.
But not a lawyer employed by the public defender's office?
That's a good question. I'm not.
You don't know?
I have no idea.
So I only have the authority to appoint the legal agency, not a specific attorney. So I've appointed the public defender's office to represent you. If your current lawyer is also employed by the public defender's office, more than likely the same lawyer will pick this case up as well. your existing lawyer is not employed by the public defender's office, but you want that lawyer to take this case too. What you can do is, if you have contact information for that lawyer, or at your next court hearing when you are face-to-face with that lawyer, let that lawyer know that you were seen on this new case. Keep that paperwork. It has the case number. And if that lawyer is able to and wants to take this case, then they could pick this case up.
Okay. I believe that's what he was trying to do, so.
Oh, did he know this was coming?
Yes.
Okay.
I was supposed to get I knew my last court date. He said that there was going to be another case pending, and as soon as he got information on that, he'd contact me, so.
Do you have his contact information?
I do.
Okay, so I would say when you get to a point where you are able to contact him, give him a call or shoot him an email, however you're in communication with him, and let him know you were seen on this case. Give him the CR number off the top of that paperwork and say, hey, I had my initial appearance on this grand jury case, and then he should know what to do from there to take this.
Thank you.
Okay, you're welcome. Go ahead and sit back and get your paperwork. Bobby Jones to the podium in the courtroom, please. Anthony Marsh, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Bobby Eugene Jones, 22183.
Thank you, Mr. Jones. You are here on an initial arrest warrant issued by the Page Justice Court. The allegations in that warrant are 2 counts of aggravated assault with a deadly weapon or dangerous instrument. They are both Class 3 felonies, both alleged to have been committed February 1st of 2025. I have determined that you are entitled to a court-appointed lawyer to defend you against these allegations. That lawyer will be appointed for you by the Page Justice Court judge at your next court hearing. That hearing will be an arraignment hearing March 19th. It'll be at 8:30 in the morning in the Page Justice Court. And on that warrant, you have a $20,000 secured appearance bond. If you post that bond and you are released from custody, in addition to getting yourself to your court hearing in Page on March 19th, you are also ordered not to have contact with any alleged victims or witnesses of the underlying allegations, and you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Mr. Jones. You can work your way back to your left. Brian Fruler to the podium in the courtroom, please. Manuel Mongi, if you'd work your way to the chair. Can I have your name and date of birth, please, sir?
Brian Christopher Further, 9/11/86.
Thanit's very much, Mr. It's Freuler?
Yeah, Freuler, it's German.
Okay, Freuler. All right, sir, you are here on an arrest warrant issued after a direct complaint was filed. A direct complaint is a written document that in this case alleges one new allegation against you. The allegation in that direct complaint is 1 count of organized retail theft. It is a Class 4 felony. It is alleged to have been committed July 6th of 2024. I have appointed a lawyer to defend you against that allegation. Your next court hearings will be a status conference March 20th and then a preliminary hearing March 24th. They will both be at 8:30 in the Superior Court downtown. On that warrant, you have a $7,500 secured appearance bond. If you post that and you are released from custody, you cannot return to the scene where the underlying theft allegation took place. You cannot have contact with any alleged witnesses, and you cannot possess any drugs without a valid prescription. Yes, sir.
Well, how can I have a warrant if I didn't have I was never charged?
These are the charges. So the warrant was issued after the direct complaint. The direct complaint is the charging document. So when the county attorney's office filed those formal charges. What?
Where did it take place?
Where did the underlying theft take place? I don't have the factual allegations. I just have the warrant. So that's what I was saying earlier. Talk to your lawyer about the facts of your case.
So, this was a year ago. I have no idea what they're talking about.
A little bit less than a year, but yeah. So talk to your lawyer. Your lawyer can give you all the factual information. Anthony Marsh to the podium in the courtroom, please. And then if I could have Devani Glover to the second chair. Anthony Marsh. I can't help you because I don't have photos. Okay. Manuel Mongi. Monge. Monge. Oh, it's Spanish. Okay. Monge. All right. I know you just sort of said it, but can I have you state your name and tell me your date of birth?
My name is Manuel Monge, 6/4/1985.
Thank you, Mr. Monge. You are here on an arrest warrant issued after a direct complaint was filed alleging new allegations against you. The allegations in the direct complaint are 1 count of dangerous drug possession, 1 count of narcotic drug possession, those are both class 4 felonies, and 1 count of drug paraphernalia possession, a class 6 felony. The direct complaint alleges that those allegations were committed April 27th of 2024. I have appointed a lawyer to defend you against those allegations. Your next court hearings will be a status conference March 20th and then a preliminary hearing March 24th. They'll both be at 8:30 in the Superior Court downtown. On that warrant, you have a $2,500 secured appearance bond. If you post that bond and you're released from custody, you cannot possess any drugs without a valid prescription once released. Do you understand those conditions?
Yes, Your Honor.
Okay, thank you, Mr. Monhay. You can step back and get your paperwork.
Thank you.
Devani Glover to the podium in the courtroom, please. Brianna Vasquez, if you would work your way to that first chair. Laura Box, if I could get you in the second chair, please. Can I have your name and date of birth?
Devin Glover, December 23rd, 2002.
Thank you very much, Ms. Glover. And can I ask you to pull your hood down just while you're at the podium? All right, thanks. You are here on 3 probation violation warrants. In all 3 cases, petitions to revoke your probation have been filed. They all allege that you have violated terms 3, 4, 5, 7, and 15. You are entitled to a court-appointed lawyer in all 3 of those cases, and I've appointed one for you in all of them. Your next court hearing on all 3 cases will be a revocation arraignment March 21st. It'll be at 8:30 in the Superior Court downtown. On each of those 3 warrants, you have a $750 secured appearance bond. So that means your total bond will be $2,250. It is all secured appearance. If you post that and you are released from custody, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yeah.
Okay, thank you, Ms. Glover. You can work your way back to your left and get your paperwork. Brianna Vasquez, if you would please work your way into the courtroom. Mary McGraw, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please?
Brianna Vasquez, 52989.
Thank you, Ms. Vasquez. You are here on 3 different matters. The first matter that you're here on is a bench warrant issued by the Maricopa County Superior Court when you failed to appear at a not guilty arraignment hearing in an existing felony trespassing case. You have a lawyer already assigned to you in that case. That lawyer will continue to defend you. Your next court hearing in that Maricopa County case will be an arraignment hearing March 21st. It'll be at 8:30 in the Superior Court downtown. On that warrant, you have a $750 secured appearance bond. The other 2 warrants you're here on are both felony warrants issued by the Pinal County Superior Court. One looks like a felony drug and misdemeanor shoplifting case. The other appears to be a felony drug and driving under the influence case. In both of those cases, if you already have a court-appointed lawyer, that lawyer will continue to represent you. If you do not, the Pinal County Court will appoint one for you at your next court hearing. Your next hearing in those 2 Pinal County cases will be an arraignment hearing March 19th at 8:30, those 2 in the Pinal County Superior Court. On the 2 Pinal County warrants, you have a total secured appearance bond of $1,250. It is $750 on the drug and DUI warrant, $500 on the drug shoplifting warrant. So $1,250 total on the Pinal County cases, $2,000 even, all secured appearance for all 3 cases. If you do post that bond and you are released from custody, you cannot have any drugs without a valid prescription or any alcohol. Also, if you do post that bond and you're released from custody, please remember it will then be your responsibility to get to Pinal County on the 19th and then be back in Maricopa County on the 21st for all of your hearings. Do you understand that information?
Yes.
Okay, thank you, Ms. Vasquez. You can work your way back and get your paperwork. We have Marsh now? Okay, Anthony Marsh, if you would please work your way into the courtroom. Ms. Box, Ms. McGraw, if you are still in the chairs, please stay there. You'll be the 2 up next. Can I have your name and date of birth, please, sir?
Anthony March, November 27, 96.
Thank you very much, Mr. Marsh. You are here on 2 different matters. The first matter that you're here on is allegations of new charges. Those allegations are 2 counts of burglary. They are both class 4 felonies. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you against them. Your next court hearings on those allegations will be a status conference March 24th, and then a status conference March 20th, and then a preliminary hearing the 24th. Both of those hearings at 8:30 in the Superior Court downtown. On those new allegations, I have imposed a $5,000 secured appearance bond. The second matter that you're here on is a probation violation warrant. In that case, a petition to revoke your probation was filed. It alleges that you have violated terms 3 and 5 of your probation. I've also appointed a lawyer to defend you in the probation proceedings. Your next court hearing in the probation case will be a revocation arraignment March 21st, also at 8:30 downtown. On that warrant, you have a $500 secured appearance bond. So your total bond will be $5,500, all secured appearance. If you post that and you are released from custody, you cannot possess any weapons or any drugs without a valid prescription, and you cannot return to the scene where the alleged burglaries took place. Do you understand those conditions?
Yeah.
Okay, thank you, Mr. Marsh. You can step back and get your paperwork. Laura Box to the podium in the courtroom, please. Ivan Heredia, if you would work your way to the second chair. Can I have your name and date of birth, please?
Laura Sue Weed, 1/27/1971.
Thank you very much, Miss Weed. And I apologize. I did not see that you now go by a new name, so I apologize for that. Okay, you are here on 2 bench warrants, both of them issued by the probation court when you failed to appear at probation violation hearings. In both of those cases, you already have a lawyer assigned to represent you, so that lawyer will continue to defend you. Your next court hearing in both of those cases will be new violation hearings. It's only one. So March 21st at 8:30, you'll have a new violation hearing, but both of those cases will be on that calendar.
What new violation?
It's not a new violation. It's a new hearing to replace the one that you allegedly missed.
Yeah.
So the title of that hearing is just called a violation hearing.
Okay, because I was late.
Okay.
I didn't attend, but the prosecutor was already gone, so they said that they...
So it doesn't matter if you're not there when the judge calls your name, it's going to be whether you showed up 1 second after or you never showed up at all, it's the same thing, legally speaking. So talk to the lawyer that's assigned to you about the facts of that. Go to that next hearing on the 21st at 8:30. On these 2 warrants, you have a total secured appearance bond of $750.
They were going to quash those.
Let me see. Let me take a look.
Because that's what they were trying to do. They were trying to get the hearing to quash that. And they said, don't get in trouble. I said, okay. And
so I'm not saying you're wrong, but I have no indication in the court record that a motion to quash was filed. I have no indication that the court did in fact quash those warrants. So every indication to me is that on the date you were picked up on these warrants, they were valid. If you think that I'm wrong about that or that there's been some misunderstanding, you can talk to your lawyer, but there are no current motions to quash or orders to quash in the court records. Any other questions?
So I have to pay a bond to get out?
Yes. Yeah. Anything else?
I can't quash them right now?
Well, you don't now. It's too late because you've already been arrested on them. So the warrants themselves are not, they're already executed. So they're no longer in the system because you were arrested on them. So they don't need to be quashed now.
What do you mean?
Well, there's 2 ways to get rid of a warrant. One is you can have it legally quashed. The other is you could be arrested on it. They both have the same legal effect. The warrant is no longer in existence.
Okay, so I have no warrant, but I have to go to court?
Correct.
And I can't be released on my own recognizance?
Correct. Yes. Any other questions?
When is the court date?
March 21st at 8:30.
And what is the date today?
Today is March 15th.
Okay.
Okay, thank you, Ms. Weed. You can step back and get your paperwork. Mary McGraw to the podium in the courtroom, please. Roger Haytasing, if you would work your way to the second chair. Can I have your name and date of birth, please?
Mary McGraw, 9/29/1980.
Thank you, Ms. McGraw. Excuse me. You are here on a probation violation warrant. A petition to revoke your probation was filed. It alleges that you have violated terms 3 and 5 of your probation. I have appointed a lawyer to defend you. Your next court hearing will be a revocation arraignment March 21st. It'll be at 8:30 in the probation court downtown. On that warrant, you have a $100 secured appearance bond. If you post that bond and you're released from custody, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Ms. McGraw. You can step back and get your paperwork.
Okay.
Ivan Heredia to the podium in the courtroom, please. Elizabeth Van Sickle, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Ivan Heredia, 11/16/99.
Thank you very much. You are here on a failure to appear warrant issued by the East Mesa Justice Court on a misdemeanor case involving furnishing tobacco to a minor. Because the underlying allegation in that case is a misdemeanor, the nature of that charge does not entitle you to a court-appointed lawyer. If you wish to have a lawyer defend you in that case, you do still have the right to hire a lawyer at your own expense. Your next court hearing on that warrant will be an arraignment hearing April 2nd. It'll be at 9 o'clock in the East Mesa Justice Court, and I am releasing you on your own recognizance on that warrant. So that means it's going to be your responsibility to get yourself to the East Mesa Justice Court on April 2nd at 9 o'clock in the morning. Do you understand that information?
Yeah, if I'm still in custody, how would I go about doing that?
You will still be in custody on something else on April 2nd?
Yeah.
Okay, so thank you for telling me that, because the answer to your question is you won't be able to get yourself there if you're in custody.
Right.
So if I don't put a bond on this, MCSO will not transport you. So what I'm going to do is I'm going to put a small bond on this case. I'll put a $50 secured appearance bond on it. The purpose of that bond is to ensure that that court hearing gets put into the MCSO system and MCSO takes you to court. The purpose of that bond is not to saddle you with more financial burden. So when you go to court, two things are going to change. One, now you're going to be entitled to a court-appointed lawyer because of the bond issue, and your court hearing is going to get bumped up to the 19th, March 19th. So when you go to court on the 19th at 8:30, there will be a lawyer for you for purposes of the bond issue. Please let that lawyer know that the bond was put on this case so you would be transported. That lawyer can then talk to the judge that you see in East Mesa and get that judge, assuming everything gets resolved on this case, to drop that bond so you don't ever have to pay it.
Okay. Yeah, I didn't go to court because I was here.
Okay. Okay, so you'll have a $50 secured appearance bond. You will now be entitled to a court-appointed lawyer for purposes of the bond issue. Your hearing will now be the 19th at 8:30 instead of the 2nd at 8:30. MCSO will take you to that court hearing. Okay, any questions? Do you understand why I did what I did?
Yeah.
Okay, all right, thank you very much. If you'll step back to your left, we'll get that reprinted and bring it out to you. Roger Hay Tasting to the podium in the courtroom, please. Mazen Jardak to the chair. Can I have your name and date of birth, please?
Roger Stanley Hadising. And my birthday is January 31st, 1972.
Thank you very much. It's Hadising?
Like you hate to sing, Hadising.
Oh, okay. Thank you, Mr. Hadising. Okay. You are here on an allegation of a new charge. That allegation is 1 count of criminal trespassing in a residential structure. It is a Class 6 felony. I have found probable cause to support that allegation, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 31st, and then a preliminary hearing April 2nd. Both of those hearings at 8:30 in the Superior Court downtown. I am releasing you to the supervision of pretrial services. So what that means is you will be released from custody. You do not need to post a bond.
Okay.
Once you are released from custody, it will be your responsibility to get to both of those next court hearings. You will also be responsible for making contact with pretrial services. With your release paperwork, you'll get a packet from them. Their contact information will be in there. So please keep that so that when you're out, you can give them a call.
Okay, so then, coming Mondays when I contact pretrial services?
Yes, they're open normal business hours, so I believe their hours are Monday through Friday, 8 to 5. I could be wrong about that, but their hours should be in that packet.
Okay.
So yeah, by Monday, I would say by close of business Monday, reach out to them.
Okay.
Also, once you're released from custody, you can't go back to that location where the alleged trespassing took place, and you can't possess any drugs without a valid prescription. Okay, any other questions, Mr. Hadesing?
No, ma'am. Thank you.
Okay, thank you very much. You can step back. Elizabeth Van Sickle to the podium in the courtroom, please. Jonathan Flulin to the chair. Good morning. Can I have your name and date of birth, please?
Elizabeth Van Sickle, 11380.
Thank you, Ms. Van Sickle. You are here on a warrant, a failure to comply warrant issued by the North Mesa Justice Court. It looks like it is on a misdemeanor extreme driving under the influence allegation. Because that is a post-adjudication matter, meaning it is post-disposition, you're not entitled to a court-appointed lawyer. You do still have the right to hire a lawyer to continue to work with you in that case if you wish to have a lawyer represent you. Your next court hearing on that warrant will be an arraignment hearing April 3rd. It'll be at 1 o'clock in the afternoon in the North Mesa Justice Court. I am releasing you on your own recognizance on that warrant, so it will be your responsibility to get yourself to the North Mesa Justice Court April 3rd at 1 o'clock in the afternoon. Do you understand that information?
Yes, thank you.
Okay, thank you, Ms. Van Sickle. You can step back and get your paperwork. Mazen Jardak to the podium in the courtroom, please. Can I have your name and date of birth?
Mazen Jardak, January 24, 1989.
Thank you very much, Mr. Jardak. You are here on an allegation of a new charge. That allegation is one count of assault. It is a Class 1 misdemeanor. I have found probable cause to support that allegation, and I've appointed a lawyer to defend you. Your next court hearing will be an arraignment hearing April 1st. It'll be at 8 o'clock in the Paradise Valley Municipal Court, 8 o'clock in the morning, 8 o'clock a.m. in the Paradise Valley Municipal Court. I am releasing you on your own recognizance with several conditions. Once you are released from custody, you are ordered not to return to the scene where the alleged assault took place, and you cannot have contact with any alleged victims or witnesses.
Just a question.
Yes.
Can I call my mom, or you mean just my brother? I cannot talk to him.
Ooh, is your mom
She lives in there.
Is she a witness? Did she see the underlying events happen?
Yeah.
Is she the only other person you could reach out to for assistance once you're out of custody?
Yes.
Okay.
And then also, how I'm gonna get my stuff out of the house.
So we'll get to that. Okay, so you can have contact with your mom. You cannot have, is your brother the alleged victim?
Yes.
Okay, so you can have contact with your mom, you can talk to your mom, but you cannot have contact with your brother.
Okay.
You also still can't go back to the scene where this occurred, so you will have to find an alternate residence. You have to find some place to stay between now and at least your first hearing on April 1st.
Yeah, I can stay at my girlfriend's place.
Okay, in terms of getting your stuff, you can have one civil standby. That means that you can reach out to local law enforcement to take you back to that location to retrieve any items that are there that you might need between now and April 1st. So to do that...
Can you do that today?
You can do that whenever you want to. So you're going to be released from custody, and what you do from there is up to you. So once you're out of custody, you can call local law enforcement and say, hey, I have a civil standby. I need an escort back to a location. They can tell you, we have an officer to meet you there. Come to the station. They'll tell you how to go about that.
Okay.
If they say we don't have an officer right now, you could try a different agency, or you can wait until they have an officer available to go there.
Okay.
But most importantly, please don't just go back to that location without having a law enforcement officer present, because that would be a violation of these release conditions and you could end up back in custody. So please comply with whatever the law enforcement agency says in order to get an officer to take you back there.
We'll do that. But I have to hire an attorney, right? For the court?
No. So I determined that you're entitled to a court-appointed lawyer. So you will get a court-appointed lawyer, but that lawyer won't be appointed for you until you see the next judge on April 1st. You do have the right to hire a lawyer, though, if you don't want to use the court-appointed lawyer. So when you get out, if you want to reach out to lawyers, you have every right to do that. If you hire a private lawyer, then the court will never appoint one for you. But if you don't hire a lawyer and you want a public defender, you'll have one present when you go to court on April 1st.
Okay.
Okay, any other questions?
No, that will be it.
Okay, thank you very much. It sounds like we're reprinting your paperwork here now, so if you'll hang out just 1 second, we'll bring it to you. All right, thank you, sir. You can work your way back to your left.
Thank you.
Jonathan Flewin to the podium in the courtroom, please. Good morning, sir. Can I please have your name and date of birth?
Yes, ma'am. Jonathan Llewellyn, September 17, 1989.
Thank you very much. And it's Llewellyn.
Yes, ma'am.
Okay, I'm sorry about that. Thank you, Mr. Llewellyn. All right, you are here on a felony arrest warrant issued by the state of Texas. Before you were put on a court docket here in Arizona, Arizona confirmed with Texas that that is a valid warrant. Texas has indicated that they are willing to extradite you. That means Texas wants to come to Arizona and take you back to Texas. Before you came into the courtroom, did you get that big laminated card to review? Okay, did you read through that? Okay, as I indicated, you're here on an out-of-state warrant. Because of that, your hearing is going to look a little bit different than everybody else that's already been heard on the calendar. I am going to tell you that you have two choices. I will explain what those two choices are. I will give you an opportunity to ask any questions you have about those choices. And then at the conclusion of your hearing, I'm going to ask which of the two choices you choose. Okay, first choice is you can choose to waive your right to an extradition hearing here in Arizona and agree to go back to Texas. If you pick that option, you are waiving your right to an extradition hearing here in Arizona. You are not waiving any rights or defenses you have to whatever the proceedings are in Texas. You are only waiving your right to a hearing here in Arizona. If you pick that option, you are in essence saying Texas can come to Arizona and take you back to Texas. If you pick that first option and you waive your right to an extradition hearing, you will be held here in Arizona without bond for up to 30 days to allow Texas an opportunity to come get you. That 30-day time period will start ticking tomorrow unless you have unresolved criminal charges pending anywhere in Arizona. If you do, that 30-day time clock will not start ticking until your Arizona criminal charges are resolved. So option one is waive your right to an extradition hearing here in Arizona, agree Texas can come and get you, stay in custody, no bond for up to 30 days. The second choice you can make is to choose to have an extradition hearing held here in Arizona. If you pick option two, I will set an extradition hearing for March 24th at 1:30 in the afternoon. Extradition proceedings in Arizona are civil proceedings, not criminal proceedings. What that means is I could not appoint a lawyer to represent you if you picked option two and had that extradition hearing, but you, like everybody else, have the right to hire a lawyer to be present and represent you if you pick option two and I set that hearing and you wish to have a lawyer. If you pick option two and I set that hearing, governor's warrants are then sought by the governors of Arizona and Texas. It is the execution of warrants by both governors that then obligates Texas to come to Arizona and obligates Arizona to release you to Texas. That process of obtaining a governor's warrant could take up to 90 days. If you pick option two and I set that hearing and those governor's warrants are sought, you are bond eligible on the Texas warrant. Your bond would be $50,000 secured appearance. If you posted that bond, you would be eligible for release from custody, but you would be required to stay in Arizona. If you picked option two and did not or could not post that bond, you would then stay in custody during that potential 90-day time period where governor's warrants are sought. Do you understand the two different options?
Somewhat.
Do you have questions about either option?
Yeah. So, excuse me. There was already a bond for that, for the Texas case. I would have to be, if I chose option two,
Yes.
Why would it have to be a separate, different bond?
I don't know what you mean by a different bond. Are you saying that Texas has imposed a bond for you in Texas on that warrant?
I've been out on bond for that. And then it's Tarrant County. Tarrant County pretty much removed the case from their system.
Well,
that's why, like, when I got arrested at the first arresting agency, I asked to see the warrant because I was even told by the clerk that they had.
When do you know when you were put on bond? Like when you posted the bond in the Texas case?
Yeah, I was arrested. I want to say it was just like a day or two before Mother's Day of last year, 2024.
May of 2024?
Yeah, 2024.
So, okay, I don't know exactly what happened. I can't tell you why the warrant was issued. Only Texas can, but I can tell you the warrant was issued September 27th of 2024. So if you were arrested and bonded out in May, my best information would be that something happened in September. I don't know whether it was an alleged violation of a release condition. I don't know if it was a missed hearing. I don't know if it was a failure to comply with some court term, but it looks like something happened in September that they then issued a new warrant. So that's why the second bond is imposed, because some condition or obligation that the court imposed was allegedly not complied with, so the Texas court issued a new warrant in September.
Okay, yeah, I was still going to reporting to bond, to the bill bond after September.
I don't know about in Texas, but in Arizona, it is not uncommon for bonding companies and courts not to communicate. So it could be something totally different in Texas, but in Arizona, you could be fully communicating and complying with the terms the bonding company has imposed and still miss court hearings or something like that. I don't know that that's what's happening here because I don't know how it works in Texas, but this would not be an uncommon situation if it were under Arizona law.
Okay, so let me see. Well, let me ask this. I think I'm going to end up going with option one.
Okay.
Let me ask this.
Sure.
So, as far as Arizona court, am I being presumed to be guilty in Texas for this?
No. Arizona is not seeing you at all on the underlying criminal allegations in Texas. The only stake Arizona has in this case is because of the fact that you are physically present in Arizona. And so because of that, if you waive your right to an extradition hearing, then you just stay in custody and Texas will come get you. If you do not waive your right to an extradition hearing, Arizona's only stake in this case is whether or not Texas can come to Arizona and physically remove you. Arizona has no position, takes no position, is not adjudicating in any way whatsoever anything that is criminally pending in Texas. So whether you waive your right or not, even if you pick option 2 and you go to court for the extradition proceedings in Arizona, the only issue to be determined at that hearing is whether Texas can come to Arizona and take you back. Arizona is not making any determinations about the underlying criminal case in Texas. So no, nothing that you do in Arizona, unless you stated on the record, I committed all these crimes in Texas, nothing that you do in Arizona will waive rights or defenses or make presumptions against you in the Texas proceedings.
Okay, so to kind of see if I can kind of get somewhat understanding of it. Option 2, I would have a hearing, extradition hearing on the 21st of this month. 24th of this month. But then it would be up to the governor of Arizona and Texas to decide that, and then I would pretty much still have to, or could be held up to 90 days.
Correct. Well, yes. So the extradition hearing is set for the 24th. That is the beginning of the extradition process. The end of the extradition process is governor's warrants getting signed by both states. From start to finish, that process could take up to 90 days. It could be 30 days, it could be 45, but it could be up to 90. The difference is that if you picked option 2, in that 90-day time period, you are bond eligible. So you could potentially be released from custody if you posted that bond.
Yeah, but then it's a $50,000 bond.
Yeah, Yeah, but if you picked option 1, you have no option of bonding out.
But option 1, they have pretty much 30 days.
They have 30 days to come get you, yeah.
Okay.
So it's a longer time period in option 2, but the exchange is that you're bond eligible.
Now, let me ask this now. If I take option 1.
Yeah.
And, because I guess it seems like there's a miscommunication between, like you said, the bond agency and probably Tarrant County, the court in Texas. If it's an issue of miscommunication on whether the bond is still active or in effect, if within that 30 days, if I take option 1 and that gets reinstated or it gets straightened out, would I be bondable here? Would I be able to?
You would never be converted from no bond to bond, but if there has been some miscommunication, and that's why this warrant was issued, and you resolved the underlying miscommunication, Texas could release their hold and say, you're holding a fugitive of justice for us to come pick up. We're not going to come get him. We're releasing our hold, and then you would be released.
Okay. All right. So
that's true in the second option too, though. So if you picked that hearing and you posted that bond and you were out of custody and you, from Arizona, got the Texas situation resolved, Texas could then also release their hold, and the extradition judge that's seeing you in the extradition proceedings would close out that case, and you would be eligible for release. I mean, the bond would go away in that case too. So if it is a miscommunication and the miscommunication is resolved, the warrant and Texas's warrant and hold will be released, and regardless of which option you pick, the legal proceedings in Arizona would stop.
Okay. I think I'm probably gonna go with 1, just because it's like the more cut and dry version, and I know I'm more than likely I'm gonna go ahead and file a tort claim against the Texas court for this. Because I actually have, I got it with me. Well, not here where I'm at, where they file stamped the last thing and like disposed of this stuff. So, but I know that's not.
Yeah, and if you get that resolved on day 3 and Texas removes their hold and you're still in custody, they'll cut you loose.
May I ask this? Is there a way that I can, for my own inspection, if I can get a copy of that warrant? So that
you have to get it from Texas. So when I get them, I don't get the physical copy like you would see. I get an electronic submission that's done through a law enforcement process. So you'd have to contact the Texas court and get them to send you a copy of their court record.
Is there a way? Well, the guy at the Avondale jail, he showed me one. Is there a way I can get that?
You could if you contact Avondale.
It wasn't a signed warrant. That's why
I don't know what he had. So yes, if Avondale showed you something that is what they're saying is the warrant, you could contact Avondale PD and ask them for a copy of it.
Okay. Outside of whichever I pick, is there a way? What way would I be able to challenge my holding here and challenge the legitimacy of that warrant?
In the extradition process. So if you want to challenge the legitimacy of the warrant, then don't waive your right to extradition. Have the hearing. That's the purpose of those proceedings, is to determine whether Texas is legally allowed to extradite you. And if that warrant's not valid, they can't extradite you. So that is the substance of the extradition proceedings.
But then I would kind of be held at the mercy of that 90 days. And see, I'm out here with a 4-year-old child. So okay, so now I'll take option 1.
Okay, I just want to confirm, you understand by picking option 1, you are waiving any challenges to the extradition process. You're agreeing Texas can come and take you back on that warrant. So you're in essence agreeing that arrest warrant is valid.
I don't agree with it, but I'm gonna accept that option. I don't agree with any of it, but I'm gonna accept that option.
Okay, maybe agree is the wrong word, but you understand that by waiving your right to an extradition hearing, you are in essence accepting that Texas has issued a warrant and you're allowing them to pick you up on that warrant.
I'm not going to say that either, but I'll take it.
I'm telling you that's what's happening.
Yes,
so if you waive your right to an extradition hearing, you are saying a warrant was issued by Texas and I am allowing Texas to pick me up on that warrant.
No, I'm not going to say that either.
then I can't accept a waiver from you. So then I have to set an extradition hearing, and you have to go to the extradition judge and challenge that warrant.
No, I still want to take option 1.
I can't accept a waiver from you if you're not agreeing that Texas can come pick you up on that warrant, though.
Okay.
So here's what's happening is you're telling me that you don't believe that is a validly issued warrant.
I'm kind of like, I know it's not a valid warrant.
Yeah, so because of that, I can't accept a waiver from you, because the first thing that you're going to have to tell me when I accept this waiver is that I understand a warrant was issued by Texas, and I agree to waive my right to challenge that warrant here in Arizona.
Yeah.
And you keep telling me I'm not going to agree to that. I don't agree to that.
Yeah, I mean, any of it, I can't agree with any of it, but if you want to accept option 1, then if you're just going to put me on option 2,
yeah, legally I don't have a choice to do anything other than that, because you're telling me that you don't believe that's a valid warrant. And so because you don't believe that that's a valid warrant, you won't agree that Texas can come pick you up on it. And
well, I won't. I'm not going to oppose Texas come get me. If Texas come get me, I'm not going to fight it. I'm going to go with them and I'll handle it in Texas. That's the case. That's all I'm saying. I'm just saying, pretty much what I'm just want to say is that the case is not an active case. The case, I don't believe there's a warrant. That's why I asked for to inspect the warrant if there's an actual warrant. I feel like I'm being pretty much held against my will here and deprived of my civil rights without a lawful warrant. So,
yeah, and so what I'm telling you is your opportunity to make those arguments and those challenges in Arizona is in the extradition process. So because it is my understanding that you feel like this is not a valid warrant, you feel like your detention and arrest on the warrant was unlawful, I can't accept a waiver from you, because it basically means you're giving up your right to make those arguments. Unless you're telling me you understand or you believe all of that, and you understand that by waiving you are basically forfeiting your right to make all of those arguments in an Arizona court. Do you wish to forfeit your right to make all of those arguments here in Arizona?
So that's what I'm trying to get to understand. So it's pretty much just like to accept option 1, I have to pretty much admit or agree that I believe the charges or the warrant for Texas is valid.
You have to, in order to accept option 1, you have to waive any challenges to the warrant here in Arizona. Because you're basically, if you pick option 1, you're basically saying, I get it, Texas, come get me, right? But then once you get back to Texas, because you've been arrested on this warrant, you can't challenge the warrant because you've already been arrested on it and you've waived your right to extradition proceedings. You've forfeited your right to challenge the warrant.
So it's like I would be forfeiting my right to challenge the warrant, period.
If you waive your right to an extradition hearing, yes. That's why I'm telling you I'm not inclined to take your waiver. Okay, so Mr. Llewellyn, what if I do this? So what if I agree to drop that bond to $25,000 secured appearance? That would potentially allow you to bond out through a bonding company for probably about $2,500. As opposed to the $50,000. I'll cut it in half, but I am not comfortable accepting a waiver because it sounds to me like you're telling me you want to challenge the warrant. And the extradition proceedings here in Arizona are the way that you do that. And if you go to court on the 24th at 1:30 and you say, I don't think this is a valid warrant, here's the information or the documentation I have. Say the Arizona court agrees with you and says, you're right, this isn't a valid warrant, then you're released on the 24th.
Yeah, but if I'm in here, if I can't afford the bond right now, and I'm in here, I can't even, provide with my documented evidence. If I'm in,
yeah, but if you pick option 1, you don't even have the right to do that.
Yeah, but it'll get me to my son quicker.
Maybe. I mean, if the warrant's not valid, you could be back to your son on the 24th or 25th after that hearing. I guess what I'm trying to tell you is I have to make findings in order to accept your waiver that you are knowingly, intelligently, and voluntarily waiving your right to an extradition hearing. And it sounds to me like even if you were to waive your right and pick option 1, you're doing it reluctantly You're not doing it because you agree that this is a valid warrant and Texas can come pick you up on it. And because of that, I'm not comfortable accepting that waiver. So I'm trying to, legally, I have to set that hearing and send you to the extradition judge. And so I'm trying to craft release conditions that somehow ease the burden of this Texas warrant in the interim.
Let's see.
What was your bond in Texas? What was the bond you posted?
$5,000.
5,000?
Yes, ma'am.
It looks like Texas is asking for you to be held without bond. But in Arizona, I can only hold people on out-of-state warrants without bond if it's post-adjudication. And I have no indication in the electronic snippet that I have that this is a post-adjudication warrant. So Texas wants you held with no bond. I do not believe I have the authority under Arizona law to hold you without bond. So the best I'll do is I will hold you on a $10,000 secured appearance bond here in Arizona on this Texas warrant. I will set that extradition hearing. It'll be March 24th at 1:30. So you still can use a bonding company. It's $10,000. You would likely be looking at $1,000 out of pocket if you go through a bonding company. If you post that bond, still go to the extradition hearing on the 24th. And if you're out of custody, try to get the information that you have about that Texas warrant, because that hearing is your opportunity to prove in Arizona that you cannot be extradited on that warrant. Okay, do you understand all that information?
Yes, ma'am.
Okay, and Mr. Fulon, I will say I do understand that you don't like it and that you don't necessarily agree with what's happening, but I hope you understand why I have done what I've done. And if that Texas warrant is invalid, and whether or not you post that bond, if you have people on the outside that could help gather information for you, I would encourage you to try to get a hold of them and start gathering what you can. If you post that bond and you're out of custody, certainly you could gather that on your own. But I strongly encourage you to try to do whatever you can to get whatever information you have regarding those Texas proceedings together so that you have that on the 24th for the extradition proceedings. Okay, any final questions for me?
I guess this is my one last hoorah. Is there any way that you could do like I'm just asking, you probably can't do this at all, but so my financial situation right now is kind of horrible. But what I do have is I have a settlement offer. I have a torn meniscus from an accident from last year. Is there a way that I can maybe, if I could just be maybe released on like a local GPS tracking system where I can at least just communicate with my insurance adjuster and accept that settlement offer and get the bond, and then I can post it?
So I cannot release you on an ankle monitor on an out-of-state warrant. That is something that you could potentially talk to a bonding company about, though, and try to use that settlement as collateral for them posting this bond. So from my perspective, the answer is no, but that doesn't mean that that's a non-starter. Back in the jail facility, there's a list of bonding companies and their phone numbers. They're all open 24/7. So if you know that you have guaranteed money coming your way, you can talk to some bonding companies and see if that's something that you can use or they will accept in order to get this posted to get you out of custody.
Okay.
Okay.
I appreciate it.
All right. Thank you, Mr. Llewellyn. Here's your paperwork if you'll step back to your left.
Thank you.
Okay, Kelly Wilson, number 11 on the calendar, Kelly Wilson, date of birth 10/13/2002, is not in the courtroom because he was unable to function in general population due to
He's on suicide watch.
Oh, I'm sorry. I thought this was the other one. He's not in the courtroom because he poses a danger to himself. He is here on allegations of new charges. Those allegations are 1 count of aggravated assault by impeding breathing, a Class 4 felony, and 1 count of child abuse, a Class 2 felony. I have found probable cause to support the child abuse allegation. I have not found probable cause to support the impeding breathing allegation. I've appointed a lawyer to defend him. His next court hearings will be a status conference March 20th and a preliminary hearing the 24th, both at 8:30. I have imposed a $50,000 secured appearance bond in that case. If that bond is posted, he will be released to pretrial services for electronic monitoring. Number 3 on the calendar, Bernice Lee Williams, date of birth 9/5/95, is not in the courtroom because he was unable to function in general population and exhibiting potentially combative behavior. He is here on 2 different matters. Both of them are bench warrants issued when he failed to appear at Rule 11 hearings. He has a lawyer already assigned to him in both of those matters. His next court hearing will be...
I think they should probably vote the status conference back in Christian Morales' court for their Rule 11 hearing. One's a probation violation.
I think we need to send them both to Christian 318 at 9 a.m. Okay, his next court hearing in both of these matters will be a status conference March 18th at 8:30. On both of those warrants, he has a $500 secured appearance bond, making his total bond $1,000 all secured appearance. If anything changes after I visit these individuals cell side, the court's final orders will be reflected in the written release orders. This court will now stand in recess until 11 a.m. You can be seated, thank you. Well, I said if you don't know how to do it, just call IACO and we'll give you more money. Okay, good morning, everybody. My name is Commissioner Hughes. This is the 11 a.m. initial appearance calendar for Saturday, March 15th. Mr. Clark, are you on the line?
Yes. Good morning, Your Honor. This is Jared Clark, Spanish interpreter. I have not been informed of any Spanish cases, but I thought I would connect just in case.
Yeah, thank you for joining us. I don't have anybody marked as requesting a Spanish interpreter, but can you guys hear the interpreter when he speaks? Yeah. No? Yes.
Me escuchan?
No.
No?
You don't hear his voice? Oh boy. Okay. Well, there we go.
Nobody? No answer.
Okay, sounds like the DO in the courtroom speaks Spanish, and he just asked the gallery if anybody needed a Spanish interpreter. Nobody raised their hand, so thank you for joining us. You can go ahead and disconnect.
You're welcome, Your Honor. Thank you. Have a good day.
You too, thanks. Okay, everyone, as we get started, did I do the fingerprint thing? No. Okay, the court's orders for the taking of DNA samples and fingerprints issued on the first calendar of March will apply to the hearings on this calendar. As we get started in here this morning, I will call each of you into the courtroom one at a time. I'll ask one of you to stand behind this gray podium here in front of me in the courtroom. I will ask the next two people that I intend to call into the courtroom to have a seat in the two chairs right inside this door. There's two chairs facing all of you. I know it seems like a little bit of an exercise to sort of progress through the chairs into the courtroom, but I promise you it will make this calendar move a lot faster and everybody will get to where they need to go a little bit quicker. So if you will please listen for your name, I'll ask, like I said, one person to come into the courtroom, one person to go to the first chair, one person to go to the second chair, and then we'll just sort of hop chairs like that through the calendar. Once you work your way into the courtroom and you're behind the podium, the first thing I will do is ask you to state your full name and date of birth. I will then explain to you why you're here. I will tell you whether you qualify for a court-appointed lawyer, sometimes called a public defender. If you do not qualify for a public defender, you have the right to hire a lawyer to represent you. That's true even if you qualify for a court-appointed lawyer. If you wish to use a private lawyer instead, you have the right to hire a lawyer in criminal proceedings. After we talk about whether you get a lawyer, I will give you the next court hearing dates and times that you'll be required to attend after this court hearing. The last thing we'll do while you're in the courtroom is talk about whether you are legally eligible to be released from custody. If you are, we will go over what terms and conditions will be applicable to your release. In addition to that right to the assistance of counsel, you all also have the right to remain silent. These are recorded criminal proceedings. That means anything that you do choose to say in the courtroom this morning will be preserved on the recording and can be used against you at any point down the line. Whether or not you qualify for a court-appointed lawyer, there will not be a lawyer in the courtroom for your defense this morning. Because you will not have a lawyer in here and because anything you say could be used against you, I will strongly caution all of you not to make any statements regarding the facts about why you're here. I encourage all of you to save any statements, questions, comments you might have about the facts of your case for a hearing where you have a lawyer present to discuss that with before you make any statements on the recording that you can't take back. Last thing I'll tell you before we get started is that all of the information I give you while you're in the courtroom will be contained in a written document called a release order. When you're done in the courtroom and you step back into the room that you're in right now, you will get a copy of that document. So please don't feel like you need to memorize the information we go through while you're in the courtroom, but please keep that paperwork with you wherever you go from here today, because like I said, in that paperwork will be all the information you got while you were in the courtroom. All right, let's go ahead and get started. Can I please have Corey Kayani all the way into the courtroom? Zachary Marchand, if you would please work your way to that first chair inside the door, the one closest to the door. And then Alejandro Hernandez, if I could ask you to have a seat in the second chair, the one closest to this wall. Okay, can I have your name and date of birth, please?
Corey Kayani, 6/27/94.
Thank you, Mr. Kayani. You are here on two different matters. The first matter that you're here on is a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing felony drug case. In that existing case, you already have a lawyer assigned to defend you. That lawyer will continue to represent you. Your next court hearings in that existing case will be a status conference March 20th and then a preliminary hearing March 24th. They will both be at 8:30 in the morning in the Superior Court downtown. On that warrant, you have a $500 secured appearance bond. The second matter that you're here on is allegations of new charges. Those allegations are one count of two counts of aggravated driving under the influence, both Class 4 felonies, and 1 count of leaving the scene of an accident. That's a Class 1 misdemeanor. I have found probable cause to support those new allegations, and I've appointed a lawyer to defend you. Your next court hearings on those new charges will in part be the same as your hearings on the existing case. So you will have a status conference March 20th and a preliminary hearing March 24th. Those are the 2 hearings that'll be the same in both of your cases.
Downtown, right?
The difference is on those new allegations, on those new DUI charges, because they are felony offenses alleged to have been committed while you were on release in that existing felony case. On the DUI charges, you are not eligible for release on bond. For those allegations, you will be held in custody without bail, at least until an evidentiary hearing is held. That hearing is scheduled for March 21st at 1:30 in the afternoon. Between now and the 21st, at that hearing on 1:30, you will be held without bond. Because of that, I encourage you to wait at least until after that hearing on the 21st before attempting to post the bond on that existing case. Do you understand that information?
Yes.
Okay, thank you very much. There's your paperwork. You can work your way back to your left. Zachary Marchand to the podium in the courtroom, please. Anthony Leva Peralta, if I could get you to work your way to that second chair. Good morning. Can I have your name and date of birth, please?
Zachary Robert Marchand, 12/17/1986.
Thank you very much, Mr. Marchand. Give me just one quick second. Okay, sorry about that. You're here on 3 different matters. The first matter that you're here on is a bench warrant issued by the trial court when you failed to appear at a trial management conference in an existing felony drug case. In that case, you already have a lawyer assigned to defend you. That lawyer will continue to represent you. Your next court hearing on that existing case will be a status conference March 21st. It'll be at 8:30 in the Superior Court downtown. And on that warrant, you have a $10,000 secured appearance bond. The other 2 matters you're here on are both probation violation warrants. Oh, I'm sorry. I'm wrong about that. You're here on 1 probation violation warrant. The other matter you're here on is allegations of new charges. So let me skip the probation warrant for a second. We'll come back to it. The allegations of new charges against you are 1 count of narcotic drug possession for sale, 1 count of discharging a firearm at a non-residence, 4 counts of possession of a weapon by a prohibited person, 2 counts of narcotic drug possession, and 1 count of discharging a firearm in the city limits. All of those allegations are felony allegations. I have found probable cause to support all of them with the exception of the drug-related charges. I did not find probable cause to support narcotic drug possession or narcotic drug possession for sale. I did find probable cause to support the weapons-related offenses. On those new allegations, I have appointed a lawyer to defend you. Your next court hearings on those will be a status conference March 20th and then a preliminary hearing March 24th, both of those hearings at 1:30 in the at 8:30. The 20th and the 24th at 8:30 in the morning. Because the new allegations that you're here on are felony offenses alleged to have been committed while you were on pretrial release in that existing case, the first warrant case, you are not eligible for release on bond on the new allegations. In that case, you will have an evidentiary hearing March 21st at 1:30 in the afternoon. At that hearing, that judge will determine after that hearing whether or not you're entitled to bond. The last matter you're here on is the probation violation warrant. In that case, a petition to revoke your probation was filed. It alleges violations of terms 6 and 7 of your probation. I've given you a lawyer in that probation case as well. Your next hearing in the probation matter will be a revocation arraignment, the 21st at 8:30, same date and time as the status conference on the existing case. On that probation warrant, you're also not eligible for release on bond. So because you will be held without bond on the new charges and the probation warrant at least until the 21st, I would encourage you to wait until after both of your hearings on the 21st. If the judge that you see on the 21st either gives you bond or releases you on that at that time, then you could look at posting the bond on the existing case warrant. Do you understand that information?
Yeah.
Okay, thank you very much. All that information will be in that paperwork. Alejandro Hernandez, if you would please work your way into the courtroom. Luis Velasquez del Palacio, if you'll work your way to the second chair, please.
Good morning.
Good morning. Can I have your name and date of birth?
Alejandro Hernandez, July 6, 1993.
Thank you, Mr. Hernandez. You are here on allegations of new charges. The allegations against you are 1 count of aggravated assault causing serious physical injury, that is a Class 3 felony, and 1 count of aggravated driving under the influence, that's a Class 4 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 20th, and then a preliminary hearing March 24th. Both of them will be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $75,000 secured appearance bond. Secured appearance means that you can use a bonding company to post that bond if you choose to. If you do post that bond prior to your or following your release from custody, in this case, you will be under the supervision of pretrial services for weekly alcohol and drug testing. So if you post that bond, you will have to check in with pretrial services to establish that testing schedule. In addition, if you post that bond and you're released from custody, you cannot have contact with any alleged victims or witnesses of the underlying allegations, and you cannot possess or consume alcohol or drugs without a valid prescription. Do you understand those conditions?
Yes, ma'am.
Okay, thank you, Mr. Hernandez.
Do I walk out?
Yes, go ahead. Thank you. Anthony Leyva Peralta to the podium in the courtroom, please. Haral Vasquez Ceballos, if you would work your way to the second chair, please. Can I have your name and date of birth?
Anthony 022706.
Can I have your full name, please?
Anthony Leyva Peralta.
Okay.
Anthony Xavier Leyva Peralta. Sorry about that.
Thank you. No, that's okay. Thank you very much. You are here on allegations of new charges. The allegations against you are 1 count of aggravated assault with a deadly weapon, that is a Class 3 felony, 1 count of possession of a prohibited weapon, that's a Class 4 felony, 1 count of disorderly conduct involving weapons, a Class 6 felony, and 1 count of carrying a deadly weapon while under the age of 21, that one's a Class 3 misdemeanor. I have found probable cause to support those allegations, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 20th, and then a preliminary hearing March 24th. Both of them will be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $50,000 secured appearance bond. If you post that and you are released from custody, you cannot return to the scene where the underlying allegations took place, and you cannot have contact with any alleged victims or witnesses. You also cannot possess any weapons if you're released from custody. Do you understand those conditions?
Yes.
Okay, thank you, Mr. Leyva Peralta. You can work your way back to your left. Luis Velasquez del Palacio to the podium in the courtroom, please. Elizabeth Mata, if you would work your way to the second chair.
Morning,
Can I have your name and date of birth? Thank you.
Luis Velasquez, January 3rd, 1980.
Okay, is your full name Luis Velasquez del Palacio?
Correct.
Okay, thank you very much, Mr. Velasquez. You are here on allegations of new charges. The allegations against you are 1 count of possession of a weapon by a prohibited person, that's a Class 4 felony, 1 count of discharging a firearm in the city limits, and 1 count of theft or being in control of stolen property. Those last 2 are Class 6 felonies. I have found probable cause for the possession of a weapon by a prohibited person and discharging a firearm in the city limits allegations. I have not found probable cause to support the theft allegation. You are entitled to a court-appointed lawyer, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 20th, and then a preliminary hearing March 24th. They will both be at 8:30 in the Superior Court downtown. And on these allegations that I have found probable cause to support, I have imposed a $50,000 secured appearance bond. If you post that and you are released from custody, you cannot have contact with any witnesses of the underlying allegations if there are any, and you cannot possess any weapons if you're released from custody. Do you understand those conditions?
Yes, Your Honor. So the bond, my family could pay it and then I could be released, right?
Your family can pay it and you'd be released. You could use a bonding company to pay it and you'd be released. So yes, you can have it posted in various different ways. The jail staff back there can talk to you about how to get it posted.
Thank you so much.
Okay, thank you. Go ahead and step back to your left.
Thank you. Your Honor?
Yeah.
I don't know if it's too late, but the bond, can it be reduced? Because right now we're going through some hardship in going.
So I am not willing to reduce it based in part on the nature of the allegations against you and the risk of harm that those types of allegations pose to the general public. I'm also not willing to reduce it because according to my review of your criminal history, you have at least one prior weapons-related conviction.
Yes, Your Honor.
So I'm not willing to reduce it. You do have the opportunity to petition the trial court for a reduction, but that wouldn't happen until you get to the trial court at your next hearing on the 20th.
No, I'm good. Thank you.
Okay, thank you very much.
Have a good one.
Harold Vasquez Ceballos to the podium in the courtroom, please. Javon Rowland, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Gyro Vasquez Ceballos.
And your date of birth?
12/10/1999.
Thank you very much, Mr. Ceballos. You are here on allegations of new charges. Those allegations are one count of taking the identity of another, that is a Class 4 felony, one count of possession of a forged instrument, one count of theft of a credit card, those two are Class 5 felonies, and one count of driving on a suspended license, that's a Class 1 misdemeanor. I have found probable cause to support those allegations and appointed a lawyer to defend you. Your next court hearings will be a status conference March 20th and then a preliminary hearing March 24th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $15,000 secured appearance bond. If you post that and you are released from custody, you cannot have contact with any alleged victims, witnesses, or co-defendants, and you cannot possess any drugs without a valid prescription if you're released from custody. Do you understand those conditions?
Yeah, I just have one question.
Okay.
So I feel like my arresting officer just ran off assumptions. I was telling him that I had just found that credit card at the airport.
I don't want you to talk to me about the facts of the case. So law enforcement submits a document to me called a Form 4. In that Form 4, they tell me their interpretation of what you told them at the arrest. But based on the collective information in that document, I did find probable cause to support these offenses. That doesn't mean that at this hearing I'm determining you committed them. What it means is that if the information law enforcement is telling me they have is true and accurate, that would be enough to establish the elements of these crimes. You have every right to challenge that information, dispute it, and present counter arguments and evidence with your lawyer at your next hearing. But I don't want you to make any statements here because I don't want you to say something that your lawyer would say you shouldn't have said that could be used against you. So I hear you saying that you may disagree or think that the information in that document or the facts against you may not be correct, and you could be right about that, but I want you to talk to a lawyer about that and present it to the next court.
Okay.
Okay, any questions about your release conditions?
No, so once I post bond, I'm out of here, right?
Yes, but then you have to show up at your next court hearing and you have to stay in Arizona.
Okay.
So if you post that bond, you can't leave the state.
Okay, so all right, I understand that. So even if I'm not from here, I can't leave the state.
Correct.
Okay.
You have to stay here at least until you go to your first court hearing. If you post that bond, when you go to court on the 20th, that judge could give you permission to leave the state. So the judge you see on the 20th is the judge that's going to undersee the whole rest of this proceeding.
I understand now.
So these are just temporary orders between now and the time you get to that judge that will see you on the underlying case.
I understand.
So if you want to leave the state, talk to that judge on the 20th. You can also call the public defender's office in your release paper. That's who I've appointed to defend you. In your release paperwork, you'll have the phone number to that office. So if you wanted to talk to a lawyer before now and the 20th, you could try to give them a call. You may not reach somebody until Monday, but you could always try.
Thank you so much.
Okay, you're welcome. Go ahead and get your paperwork. You can step back to your left. Elizabeth Mata to the podium in the courtroom, please. Terrence Yazzie, if you would work your way to the second chair. Can I have your name and date of birth, please?
Elizabeth Mata, 11/11/1989.
Thank you, Ms. Mata. You are here on allegations of new charges. The allegations against you are one count of aggravated driving under the influence, and 1 count of narcotic drug possession. They are both Class 4 felonies. I have found probable cause to support those allegations and appointed a lawyer to defend you. Your next court hearings will be a status conference March 20th and then a preliminary hearing March 24th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $15,000 secured appearance bond. If you post that bond following your release from custody, you will be released to the direction of pretrial services for alcohol and drug testing and monitoring on a weekly basis. If you post that bond and you're released, you are ordered not to possess or consume any alcohol or drugs without a valid prescription. Do you understand those conditions?
I do.
Okay, thank you, Ms. Mata. You can step back and get your paperwork. Javon Rowland to the podium in the courtroom, please. Samia Wiki, if you would work your way to the second chair. Can I have your name and date of birth, please?
Javon Rowland, 12/25/91.
Thank you, Mr. Rowland. You are here on allegations of new charges. The allegations against you are 1 count of trafficking in stolen property. That is a Class 2 felony. 3 counts of organized retail theft. They are all Class 4 felonies. 1 count of theft, a Class 4 felony. 1 count of shoplifting, a Class 5 felony. And 2 counts of altering a UPC. Those are both Class 6 felonies. I have found probable cause to support those allegations, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 20th and then a preliminary hearing the 24th. They will both be at 8:30 in the Superior Court downtown. And on these allegations, I have imposed a $7,500 secured appearance bond. If you post that and you're released from custody, you cannot return to the scene where any of the alleged underlying allegations took place. You cannot have contact with any alleged witnesses or co-defendants, and you cannot possess any drugs without a valid prescription if you're released from custody. Do you understand those conditions?
Yes, I was going to ask you, do I pay, can I be eligible for, OR with pretrial?
So those are 2 different things. OR and pretrial are 2 different things, and it's not necessarily a matter of eligibility or non-eligibility. It is a matter of weighing different factors. So when I looked at this case, I looked at the nature of the allegations against you. I looked at your criminal history, and I determined that based on the nature of the allegations and my review of your criminal history, a bond was necessary and appropriate to protect the general public, including businesses, as well as to secure your appearance in court and your cooperation with legal proceedings. So, like I said, it's not a matter of eligibility or ineligibility. It's a determination of weighing factors, and when I weighed the factors I'm required to, those factors weighed in favor of a bond. Any other questions?
No. So do I pay the whole $7,500 or the $750?
You can use a bonding company. So if you want to go through a bonding company, my general understanding is that most will require less than the full amount out of pocket up front. But when you get back into the facility, I would say find a list of bonding companies. There's a list of companies and their phone numbers. Call them. I don't want to tell you what their specific requirements might be. Any arrangements that you make with a bonding company would be between you and the bonding company, not the court.
Okay.
All right. Thank you, sir. You can step back and get your paperwork. Terrence Yazzie to the podium in the courtroom, please. Jace Young, if you would please work your way to the second chair.
Hello.
Hi, can you pull your beanie off and give me your name and date of birth, please?
Terrence Yazzie, 1987.
Thank you, Mr. Yazzie. You are here on allegations of new charges. The allegations against you are 3 counts of organized retail theft, 3 counts of using an artifice with the intent to shoplift. Those 6 are Class 4 felonies, and then 6 counts of shoplifting as Class 1 misdemeanors. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 20th and then a preliminary hearing March 24th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $5,000 secured appearance bond. If you post that bond and you're released from custody, you cannot return to the scene where any of the alleged offenses took place, and you cannot have contact with any alleged witnesses or co-defendants. Do you understand those allegations?
Yeah.
Sorry, I didn't hear you because the door was closing. Okay, thank you very much.
Can I say something?
You can, but I encourage you to proceed with caution because you don't have a lawyer in here.
Is there a way that I can go on pre-trial release or probation?
Well, probation is a post-disposition matter, so probation might be something that you get if you are convicted as a sentence in this case. It's not something that I can order pre-conviction, and based on the nature of the allegations against you, I'm not willing to release you without a bond. So you do have to post that bond in order to be eligible for release. It is possible that if you are convicted, you might end up on probation, but that will happen much later down the road. Any other questions?
So then I'm not getting released today?
Not unless you post that bond.
How much is the bond?
It's $5,000 secured appearance.
Is there a way that, they can put me on OR or anything?
No, you have to post that bond in order to be.
When's the next court date?
What?
When's the next court date?
March 20th.
March 20th? That's 5 days, huh?
5 days, yep, you got it. Yep. All right, thank you, Mr. Yazzie. You can step back and get your paperwork. Samia Wiki to the podium in the courtroom, please. William Glover, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Samia 3/13/07.
Can you say your full name?
Samia Betty Wiki.
And I'm sorry, I missed your date of birth.
3/13/07.
Thank you, Ms. Wiki. You are here on allegations of new charges. Those allegations are 2 counts of burglary, both class 3 felonies, 3 counts of disorderly conduct, 3 counts of threatening and intimidating, and 1 count of causing criminal damage. Those last 7 counts are all class 1 misdemeanors. I have found probable cause to support those allegations, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 20th, and then a preliminary hearing March 24th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $5,000 secured appearance bond. If you post that bond and you are released from custody, you cannot return to the scene where the underlying allegations took place. You cannot have contact with any alleged victims, witnesses, or co-defendants. You also cannot possess any weapons, and you cannot possess or consume any alcohol or drugs without a valid prescription. Whether or not you are released from custody, you are also strictly ordered to comply with the terms of any orders of protection, if any have been or are later served upon you.
Yes, ma'am.
Do you understand all of those conditions?
Yes, ma'am.
Okay, thank you very much. You can step back and get your paperwork. Okay, Jace Young, if you would work your way into the courtroom, please. Aylin Perez, if I could ask you to work your way to the chair. Good morning. Can I have your name and date of birth?
Jace Young, 12/01/05.
Thank you very much, Mr. Young. You are here on allegations of new charges. The allegations against you are 1 count of theft, that is a class 6 felony, and 2 counts of shoplifting, both class 1 misdemeanors. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 20th, and then a preliminary hearing March 24th. They will both be at 8:30 in the morning in the Superior Court downtown. On these allegations, I have imposed a $2,500 secured appearance bond. If you post that and you are released from custody, you cannot possess any weapons or drugs without a valid prescription, and you cannot return to the scene where any of the underlying allegations took place. Last, you cannot have contact with any alleged witnesses or co-defendants if there are any of these allegations.
I can't even get, I can't get ORs or anything because these are my first charges, like my first ever charges.
I do see that you do not have a substantial criminal history. I'm not willing to release you without a bond based on the nature of the underlying charges, as well as the fact that there's more than one of them. So you will have to post that bond in order to be eligible for release. Any other questions?
No, ma'am.
Okay, thank you, Mr. Young. You can step back and get your paperwork. William Glover to the podium in the courtroom, please. Alexis Carlson, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Williams Glover, September 27th, 1969.
Thank you very much, Mr. Glover. You are here on 2 different matters. The first matter that you're here on is a probation violation warrant. In that case, a petition to revoke your probation was filed. It alleges that you have violated terms 3, 5, and 7. I have appointed a lawyer to defend you in the probation proceedings. Your next court hearing will be a revocation arraignment March 21st at 8:30 in the probation court downtown. On that probation warrant, you have a $500 secured appearance bond. The second matter that you're here on is a warrant issued by the Surprise Municipal Court on a misdemeanor criminal trespassing case. On that misdemeanor warrant, you are entitled to a court-appointed lawyer for purposes of release conditions. That lawyer will be appointed for you by the next judge you see at your next court hearing. Your next hearing on that misdemeanor warrant will be an arraignment hearing March 25th. That one will be at 1:30 in the afternoon in the Surprise Municipal Court. On the misdemeanor warrant, you have a $50 secured appearance bond. So your total bond will be $550. It is all secured appearance. If you post that and you're released from custody, in addition to getting yourself to your court hearings, you are also ordered not to possess any drugs without a valid prescription. Do you understand those conditions?
Yes, I do.
Okay, thank you, Mr. Glover. You can work your way back and get your paperwork.
If I was injured and pretty much incapacitated by being sick, is that gonna have any effect on anything?
Potentially. I don't know the underlying allegations as to how, when, or why you allegedly violated your probation. I just know which terms you have allegedly violated. Okay. So when you go to the probation court and see the probation judge and your lawyer, give your lawyer the information all about your illness and whatever else may have been happening, and your lawyer can talk to you. And if that is helpful in your defense in that case, you and your lawyer can present that to the probation court.
Okay.
Okay. Thank you, Mr. Glover.
Thank you.
Mr. Glover, also, sorry, before you go, if you are still ill or injured and you stay in custody, please let MCSO know that so that their medical staff can see you if you need to be seen.
Okay.
Okay, thank you. Aylin Perez, if you would please work your way into the courtroom. Brian McConaughey, if you would work your way to that second chair.
Hi, hello.
Hi, can I have your name and date of birth, please?
Yeah, Eileen Perez, February 27, 2000.
Thank you, Ms. Perez. You are here on a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing felony drug case. You have a lawyer already assigned to you in that case. That lawyer will continue to defend you. Okay. Your next court hearing will be a new status conference March 20th. That'll be followed by a preliminary hearing March 24th. They will both be at 8:30 in the Superior Court downtown. On that warrant, you have a $500 secured appearance bond. If you post that and you're released from custody, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Wait, I'm not getting released?
Not unless you post that bond.
$500?
$500, yep.
Is that $50?
Well, if you want to go through a bonding company, you can call them and see what their requirements might be.
Okay.
Okay, any other questions?
That's it.
Okay, thank you very much. You can step back and get your paperwork. Alexis Carlson to the podium in the courtroom, please. Tara Lamp, if you would please work your way to the chair. Can I have your name and date of birth?
Alexis Christine Carlson, June 7, 1996.
Thank you very much, Ms. Carlson. You are here on a probation violation warrant. A petition to revoke your probation was filed. It alleges that you have violated terms 3 and 5. I have appointed a lawyer to defend you in the probation proceedings. Your next court hearing will be a revocation arraignment hearing March 21st. It'll be at 8:30 in the probation court downtown, and you have a $100 secured appearance bond on that warrant. If you post that and you are released from custody, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Ms. Carlson. You can step back and get your paperwork. Brian McConaughey to the podium in the courtroom, please. Constantina Zizzo, if you would please work your way to the second chair.
Good morning.
Good morning, sir.
Good morning.
Can I have your name and date of birth, please?
Brian Floyd McConaughey, 7257.
57, not 56?
Yeah, I don't know how that appeared there. I was born July 2nd, 1957. And it's on my license, and
It's on your license as 57?
Yeah, okay. Somebody, I don't know, somebody pushed the wrong digit or something.
It's hard to say what happened, but okay. And I'm sorry, your last name is pronounced McConaughey, not McConaughey.
Correctly. You're probably one of the second people in my life that said it correctly.
All right, gold star for me. Okay, you are here on an arrest warrant that was issued after a direct complaint was filed. A direct complaint is a written document that alleges new allegations against you. The allegation in that direct complaint is 1 count of dangerous drug possession. It is a class 4 felony alleged to have been committed October 7th of 2024. I have appointed a lawyer to represent you against that allegation. Your next court hearings will be a status conference March 31st and then a preliminary hearing April 2nd. They'll both be at 8:30 in the Superior Court downtown. I am releasing you to the supervision of pretrial services. So what that means is you will be released from custody. You do not need to post a bond. Once you are out of custody, it will be your responsibility to get yourself to both of your next court hearings. You will also be required to call pretrial services once you're out of custody. Their phone number will be in a little packet that you get from them with your release order. So please keep that. Last thing, once you're out of custody, you cannot possess any drugs unless you have a valid prescription for them. Okay, do you understand all of those conditions?
Yes, I do, Your Honor. Will it do me any good or let you know why I didn't make that appearance?
I'm not seeing you for not making a court hearing. I'm seeing you because new charges were filed against you. Yeah, so I have no indication that you are here because you didn't go to court. So go to court for these next court hearings, and hopefully we don't have to do this again.
I'll be there.
All right, very good. You can work your way back and get your paperwork. Thank you, Mr. McConaughey.
Thank you.
GyroLamb to the podium in the courtroom, please. Mindy Sublet, if you would work your way to the chair. Can I have your name and date of birth, please?
Tara Lamp, 3/19/85.
Thank you very much, Ms. Lamp. You are here on allegations of new charges. The allegations against you are 1 count of aggravated assault on a first responder. That is a class 4 felony. 1 count of assault, 1 count of disorderly conduct. 2 counts of assault. 1 count of aggravated assault on a first responder. That's a felony allegation. 2 counts of misdemeanor assault, 1 count of disorderly conduct, and 2 counts of criminal damage. Those last 4 allegations. 5 allegations. Those last 5 allegations are all misdemeanors. So 1 felony allegation, 5 misdemeanor allegations. I have found probable cause to support them. You are entitled to a court-appointed lawyer, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 31st, and then a preliminary hearing April 2nd. They will both be at 8:30 in the Superior Court downtown. I am releasing you to the supervision of pretrial services with the condition of electronic monitoring. So what that means is you will be released from custody without a bond, but prior to your release from custody, you will be affixed with an ankle monitor. Once you are released from custody on that ankle monitor, you cannot return to the scene where these underlying events took place, and you cannot have contact with any alleged victims or witnesses. You also cannot possess or consume any alcohol or drugs without a valid prescription, and you cannot possess any weapons once you're out of custody. Last thing, once you're out of custody, you are ordered to strictly comply with the terms of any orders of protection, if any have been or might later be served upon you. Do you understand those conditions?
Yes, ma'am.
Okay, thank you, Ms. Lamp. You can work your way back to your left and get your paperwork. Constantina Zizzo, if you would work your way into the courtroom, please. Franklin Amos, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please?
Yes, Constantina Zizzo, date of birth 4/20/61.
Thank you very much, Ms. Zizzo. You are here on 2 warrants, both misdemeanor warrants. The first one issued by the San Marco Justice Court on a misdemeanor driving on a suspended license allegation. The second is a misdemeanor warrant issued by the Kyrene Justice Court on a DUI, driving under the influence allegation. In both of those cases, because they are post-adjudication, post-disposition misdemeanors, you're not entitled to a court-appointed lawyer. If you don't already have a lawyer working with you in one or both of those cases, but you want one, you will have to hire a lawyer to represent you. Your next court hearing on the San Marcos warrant will be an arraignment April 1st at 10 o'clock. Your next hearing on the Kyrene warrant will be an arraignment hearing April 2nd at 9:30. I think both of those courts are in the same building. So one on April 1st at 10, one on April 2nd at 9:30. I am releasing you on your own recognizance, so you will be out of custody. That means it will be your responsibility to get yourself to court for 2 days in a row. So make sure you're at both hearings. Once you're out of custody, you cannot possess or consume any alcohol or drugs without a valid prescription, and you cannot drive a vehicle if you don't have a valid driver's license. Do you understand those conditions?
Yes, I do.
Okay, thank you, Ms. Izzo. You can step back and get your paperwork. Mindy Sublet to the podium in the courtroom, please. David Olvera, if you would please work your way to the second chair. Can I have your name and date of birth?
Mindy Marco Sublet, 224-2000.
Thank you very much, Ms. Sublet. You are here on allegations of new charges. The allegations against you are 1 count of narcotic drug possession, 1 count of dangerous drug possession, those are both class 4 felonies, and 1 count of drug paraphernalia possession, which is a class 6 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 31st, and then a preliminary hearing April 2nd. They will both be at 8:30 in the Superior Court downtown. I am releasing you on your own recognizance, so you will be released from custody. That means it will be your responsibility to get yourself to both of those next court hearings. And once you're released from custody, you are ordered not to possess any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you very much, Ms. Sublet. I need to ask my clerk to reprint your paperwork, but she'll do that and we'll bring it out to you if you'll take a step back to your left. Reprint that one, please. Okay, Franklin Amos, if you would work your way into the courtroom, please. Matthew Johnson, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please, sir?
Franklin Charles Amos Jr., 725-2000.
Thank you very much. It's Amos?
Amos.
Amos.
Amos, you can say Amos, it's Amos. It's like lovers, like...
I want to get it right, but okay.
Thank you.
All right, you are here on an allegation of a new charge. The allegation against you is 1 count of criminal trespassing in a residential structure. It is a class 6 felony. I have found probable cause to support that allegation, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 31st, and then a preliminary hearing April 2nd. Both of your hearings will be at 8:30 in the Superior Court downtown. I am releasing you on your own recognizance, so you will be released from custody. That means it will be your responsibility to get yourself to both of those next court hearings.
Thank you.
Once you're released from custody, you are ordered not to return to the scene where the underlying alleged trespassing offense took place, and you cannot have contact with any alleged witnesses of that allegation. You also cannot possess any drugs without a valid prescription once you're out of custody.
Okay.
Do you understand those conditions?
Yes, I do.
Did you have a question?
I'm kind of nervous to see you.
Okay, well, I'm sorry you're nervous, but you're going to get out of here, so go ahead and step back to your left and get your paperwork.
Thank you.
David Olvera to the podium in the courtroom, please. I have your name as Smith Tiara, but I'm guessing it's Tiara Smith. If you would work your way to the second chair. Okay, can I have your name and date of birth, please, sir?
David Olvera, October 19, 1967.
Thank you, Mr. Olvera. Okay, you are here on 2 different matters. The first matter that you're here on is an initial arrest warrant. That initial arrest warrant was issued by the Country Meadows Justice Court, and it alleges a new allegation against you. The allegation in that warrant is 1 count of contracting without a license. It is a misdemeanor offense. The second matter that you're here on is a failure to comply with court terms warrant issued by the Arrowhead Justice Court. The underlying allegation in that case is a misdemeanor issuing a bad check allegation. In both of these cases, because the allegations are misdemeanors, you're not entitled to a court-appointed lawyer. You do still have the right to hire a lawyer to represent you in one or both of these cases if you wish to. Your next court hearing on that new allegation out of Country Meadows will be an arraignment hearing April 3rd at 8:30 in the Country Meadows Justice Court. Your next hearing on the Arrowhead warrant will be an arraignment hearing April 1st, that one at 2 o'clock in the afternoon in the Arrowhead Justice Court. I am releasing you on your own recognizance in both of these cases, so you will be responsible for getting yourself to those court hearings. In addition, once you're out of custody, you are ordered not to possess any drugs without a valid prescription. Do you understand those conditions?
Yes, ma'am.
Okay, thank you, Mr. Olvera. You can step back and get your paperwork. Matthew Johnson to the podium in the courtroom, please. Okay, thank you. Can I have your name and date of birth, please, sir?
Yeah, Matthew Johnson, March 8th, 1985.
Thank you very much, Mr. Johnson. You are here on allegations of new charges. The allegations against you are 1 count of misdemeanor assault and 1 count of misdemeanor disorderly conduct. I have found probable cause to support those allegations. I have determined that you are entitled to a court-appointed lawyer. That lawyer is going to be appointed for you by the next judge you see at your next court hearing. That hearing will be an arraignment hearing April 8th. It'll be at 1:30 in the afternoon in the Surprise Municipal Court. I am releasing you on your own recognizance on these allegations, so you will be released from custody. That means it will be your responsibility to get yourself to the Surprise Municipal Court April 8th at 1:30. Once you are out of custody, you cannot return to the scene where the underlying allegations took place. You also cannot have contact with the alleged victim or any alleged witnesses. If these orders mean that I'm ordering you not to return to your primary residence, you must find an alternate residence at least until your first hearing on April 8th. You can return to the location where these alleged events took place if you need to, 1 time and 1 time only between now and your first court hearing to retrieve personal items that you have there if you need them. If you need to do that, you can only go back there that 1 time if you're accompanied by a law enforcement officer. You can make arrangements for that by calling the non-emergency number to any local police agency. Let them know you need an escort to go back to a location. They will give you further instruction on how to arrange that. Please strictly comply with the instructions law enforcement gives you, because if you go back there without a law enforcement officer or you go back more than once, that could be a violation of these release conditions, which could end up in you being rearrested and brought back here. So please strictly comply with that. If law enforcement says come to the station, do that. If they say go to the location but stay in your car or stay across the street, please strictly comply with what directions they give you. Okay, do you understand all of those conditions?
Yeah, just one question.
Sure.
So if the victim is not there, am I able to return? Because it is my primary home residence.
Does the victim live there?
It's my son, yeah.
So no. Well, is it his primary residence?
Yes.
So where would he go?
Well, he'd have to go to his grandparents because I'm the custodial parent, and his mother actually lives in Indiana.
So the problem is I don't have the authority to make orders for people that are not in court. So I don't have the authority to tell him he has to go somewhere else. Arguably, if he's under 18, this court doesn't have jurisdiction to make that order against him anyway. It would be the juvenile court. So the only authority I have is to make orders against you.
Sure.
I'm also... So if I tell you to reside somewhere else, does that mean that you have a minor child living alone?
No.
Okay.
Although one of the witnesses is my wife.
Okay.
She lives with obviously all of us.
So it is possible, tell me if I'm incorrect, but it is possible for you to reside somewhere else at least until the 8th, and your son, the alleged victim, could be cared for at the home in the interim.
Yes, ma'am.
Okay. I'm going to leave it that way. I'm not going to prohibit you from having contact with your wife. I will say, to the extent that you do have contact with your wife, I am going to order you not to discuss the content or context of this criminal case. So please don't communicate with your wife other than these release conditions. And I mean, you can tell her the court has ordered me that I have to go somewhere else. I have to have a law enforcement officer come to gather things. I mean, you can talk about that stuff, but please don't discuss the underlying facts of this case with her, because it is possible she will be called as a witness, and I don't want to see you hit with some sort of witness tampering allegation. So talking about release conditions, completely fine with your wife. Please do not discuss the facts of the underlying allegations with your wife. No contact whatsoever with your son, the alleged victim, at least until your first hearing on the 8th.
Okay.
Okay, any other questions?
No, ma'am.
Okay, thank you, Mr. Johnson. You
Thank
can
you.
step back and get your paperwork. Tiara Smith to the podium in the courtroom, please. Oh, shoot. That awake Moses up. Good morning. Can I have your name and date of birth, please?
Tiara Smith, December 23rd, 2002.
2002, not 2000?
Yeah, 2002.
So December 23rd, 2002.
Yes, I'm 22.
Okay. Thank you very much, Ms. Smith. All right, you are here on two different matters. Both of the matters that you're here on are warrants issued by out-of-state court. So one of them is a Nevada, I think it's a Nevada probation violation warrant. The other is a felony arrest warrant issued out of California. Before you were put on a court docket here in Arizona confirmed with both California and Nevada that both of those warrants are valid. Both states are willing to extradite you, which means both California and Nevada want to come to Arizona and take you back.
Who do I go with first?
Well, we'll talk about that. So I'm going to explain what the two different options you have on each warrant are. Then I'll give you an opportunity to ask questions you have about those options. So we'll come back to that because the answer to that question depends on which option you pick.
Okay.
And the last thing I'll do is get your election on each of these warrants. Okay, before you came into the courtroom, did you get that big laminated card to review?
Yes, I read it.
Okay, you read through that?
Yes.
Very good. Okay, so let's talk about your two choices. And this is going to apply to both warrants. Okay. So you're going to make a total of two choices. So you have two options, but on each warrant. So a total of 4 options, but they're the same. Okay. So at the end of this, I'm going to ask you, what do you choose on the California warrant and what do you choose on the Nevada warrant? Okay. You may make the same choice on both, you may not. So we'll go through it. Okay, first option is you can choose to waive your right to extradition proceedings here in Arizona and agree to go back to California or Nevada, or California and Nevada. If you choose to waive your right to an extradition hearing here in Arizona, you are not waiving any rights or defenses you have to the probation case in Nevada or the criminal case in California. You are only agreeing that you don't need to go through extra proceedings here in Arizona to go back to those states. If you pick that option and you waive your right to an extradition hearing here in Arizona, you will be held in custody without bond for up to 30 days to allow California and Nevada an opportunity to come get you. If you pick that option and you waive your right to extradition proceedings, that 30-day time clock will start ticking tomorrow. Unless you have local charges, if you have criminal charges pending somewhere in Arizona, that time won't start ticking until your Arizona criminal charges are resolved. Okay. If you have no criminal charges pending in Arizona, your 30-day time clock will start ticking tomorrow. If you waive your right to extradition proceedings on both warrants, both California and Nevada, you would go to whichever state came to get you first. The other state would be next in line. So if you waive on both and Nevada shows up on day 15, you would go to Nevada, deal with whatever's going on in Nevada. When you're done in Nevada, assuming California still wants you, then California would go to Nevada and you would go from Nevada to California. Same thing if California came first, you would go to California. When you're done in California, then you'd go to Nevada. Okay, that's option 1. Option 2 is you do not waive your right to an extradition hearing. If you pick option 2 on either of these warrants, I will set an extradition hearing for March 24th at 1:30 in the afternoon. Extradition proceedings in Arizona are civil, not criminal. That means I could not appoint a lawyer to represent you if you picked option 2 and had that hearing, but you do still have the right to hire a lawyer if you pick option 2 and you want to be represented. Okay. If you pick that second option and I set extradition hearings on one or both of these warrants, Governor's warrants are then sought by both Arizona and the issuing state. The process of obtaining a governor's warrant could take up to 90 days. On the California warrant, if you pick option 2, you are bond eligible. So if you pick option 2 on the California warrant, your bond would be $50,000 secured appearance. On the Nevada warrant, because it is a post-disposition warrant, you're not eligible for release even if you pick option 2. So if you pick option 2 on both of these warrants, I would set extradition hearings for both, but you still wouldn't be released from custody. So if you pick option 2, I would say you are bond eligible on the California warrant, but I would suggest that you not post that bond, because even if you did, you would still be held in custody without bond on the Nevada warrant.
Yes, I understand.
And that's true for a total of up to 90 days, which is the time period that it could take between that initial extradition hearing and getting a governor's warrant signed by both Arizona and California, or Arizona and Nevada. Okay. Do you have questions about either option?
No, I know I want option 1.
You know you want option 1?
Yes.
On both of the warrants?
Yes, I know. I knew it was bondable for the California one. So I can bond out without even going, right? To California.
No. If you pick option 1, you're not getting released. Well, you're not going to be released from custody, period.
Yeah, I understand.
Do you mean if you pick option 1, once you get back to California, you can bond out?
No, once I get back to Nevada, can I bond out from California?
I don't know. That would be up to Nevada. Okay. So if Nevada comes first and you're in Nevada, it would be up to Nevada as to what your release conditions are on the Nevada warrant there. I also don't know what Nevada fugitive laws are, so I don't know. You're bondable on the California warrant here under Arizona law. I don't know if you are still bondable on the California warrant under Nevada law.
Okay, and I have one more question. Oh, what was it? I'm sorry.
No,
you know what count? So I don't know if I'm going to Carson City, Nevada, or Las Vegas, Nevada. Does it say?
Let me see.
Okay.
I don't know. It just tells me that the agency is Nevada Highway Patrol. So it looks like the extraditing agency is the Nevada Department of Public Safety. It doesn't tell me what court or what county issued the underlying warrant.
Because I'm on probation in Las Vegas, but the crime happened in Carson City. That's why I'm confused.
It's out of
so that's Las Vegas.
So that's Vegas.
Oh,
yeah.
God. Okay.
Okay, thank you. Okay, any other questions?
Yes. What is the warrant? What county is that out of in California? Is it San Jose County or whatever it's called?
See if I know.
Oh yeah, that's San Jose. Yeah.
Okay. Any other questions?
No, I'm sorry. That's
okay.
good.
No, that's okay. And so, what choice do you want to make on the California warrant?
Both option 1.
Both of them option 1. Okay. Because you are electing to waive a right that you are legally entitled to, you're electing to waive that right to a hearing, an extradition hearing here in Arizona. I do need to ask you some questions. I just ask that you answer them out loud. Please don't shake or nod your head.
Okay.
Okay. Did you read the waiver of extradition paperwork on that big card?
Yes, I did.
Do you understand, this applies to both warrants, that you do not have to sign the waiver of extradition paperwork?
Yes.
Do you understand you have the right to have an extradition hearing held on both the California and Nevada warrants?
Yes.
Do you understand you have the right to hire a lawyer at your own expense to represent you in the extradition proceedings if you picked option 2 and had hearings here in Arizona on both warrants?
Yes.
Do you understand you have the right to demand that warrants are signed by Arizona and California by the governors of Arizona and California on the California warrant, the governors of Arizona and Nevada on the Nevada warrant, before you could be extradited if you picked option 2?
Yes, I understand.
Okay. Do you understand that as to the California warrant, if you picked option 2, you would be eligible for release on bond?
Yes, I understand.
Do you wish to give up those rights and sign the waiver of extradition paperwork?
Yes. Wait, right? Yes.
That's option 1.
Okay, yes.
Give up those rights and pick option
yes.
1?
Yes.
On the California warrant?
Yes.
And on the Nevada warrant?
Yes.
Okay. Has anybody threatened you or promised you anything in exchange for your signature on the waiver of extradition paperwork?
No.
Have you had any drugs, alcohol, or medication in the last 24 hours that would affect your ability to waive a legal right?
No.
Okay, then I will find that you are knowingly, intelligently, and voluntarily waiving your right to an extradition hearing. I will ask you to sign that waiver. I will then also sign it. Once we both sign, I will notify MCSO to notify both Nevada and California that you're ready to return. You will go to whoever comes to get you first.
Okay, can we get a full work completion? You can see my marks, okay?
Squiggle big and squiggle hard.
Your Honor, we have my birthday in there wrong?
Yeah, I think we fixed it.
sent it in correctly, but I got it.
Oh, yeah, it's like every time I go to jail, they either spell my name wrong or put the wrong birth.
Yeah, we had your name, somehow it got entered as, your name was backwards and your date of birth, we tried to make you 2 years older. Sorry.
It was us, you know. You're all good with that. Oh, yeah, I got it. Thank you.
Okay, any final questions for me?
Nothing.
All right, thank you very much. We'll get your paperwork printed. We'll get it to you. You can either stay there, go back, whatever he tells you to do. Okay, go ahead and have a seat back out there, and this court will stand in recess until 2 p.m. I did what? Oh. I was like, what'd I do?
Okay, first one?
Good.
This showerhead changed my life.
right, this is the 2 p.m. calendar for March the 15th. The court's orders for the taking of fingerprints and DNA samples made on the first calendar of the first day of the month will apply to all the matters on this calendar. Do we have counsel here on the phone already? Okay. We'll call number 4 first then. Ariana Bird, if you could step up to the podium, please. Okay, ma'am, first, please tell me your name and date of birth.
Ariana Bird, 10/6/90.
All right, and do we have counsel on the line?
Yes, good afternoon, Your Honor. Adam Feldman, form is Bird.
Okay. All right, Ms. Bird, you've been charged with aggravated DUI, class 6 felony, and failure to notify her after striking a fixture, a class 1 misdemeanor. Based on the form 4, I was not able to find probable cause. Mr. Feldman, do you want to be heard on release conditions?
No, I was going to mention that, so I appreciate that, Your Honor. As far as release conditions on the class 1 misdemeanor, failure to notify, I would simply ask for release on her own recognizance. I anticipate that the state would either dismiss and send that to the city while they try to figure out the DUI portion, or bring it all together. So I think at this point, release on her own recognizance would be appropriate.
Yeah, and that's what I was inclined to do anyway, because no probable cause on that felony. You're going to be released on your own recognizance. You're not to initiate any contact with the arresting officers. I doubt you want to see them again anyway. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address. I'm sure your attorney will explain it to you, but just because there's not probable cause based upon the Form 4 doesn't mean that there's not police reports or something else. So the case may still go forward. That'll be up to the county attorney working with your attorney. But your next court date on this case will be a status conference on March 31st at 8:30, followed by a preliminary hearing on April the 2nd at 8:30 in the Superior Court at 175 West Madison. Did you have any questions, ma'am?
No, sir.
Anything else from you, Mr. Feldman?
Judge, just so I'm aware, so I could relay this to her father, she would be released relatively soon from ITR, correct?
Yes.
Okay. All right. Thank you, sir.
Thanks, counsel. All right, ma'am, you can step back to the... All right, we're going to proceed in the following manner for the remainder of the cases. We're going to call 2 people. The first person will step to the podium. The second person will sit in the chair by the door, kind of like an on-deck circle in baseball. But first, we're going to call Maria Columba, followed by Amy Gooden. Good afternoon, ma'am. Please state your name.
Maria Chavez Columba, June 86.
Okay, thank you, ma'am. Ma'am, you're here on 3 cases, 2 probation violations and a new case. The first is number 1 on the calendar. All right, and that charges you with a probation violation for a class 4 felony. The court has found you to be indigent. It's ordered appointing the public defender to represent you. There's been a bond set in this case by the judge who issued the warrant in the amount of $500. I'm affirming that $500 bond. If you post the bond, you're not to initiate any contact with any witness or victim. You're not to possess any weapons. You're not to possess any drugs without a valid prescription. You're not to drive without a valid driver's license. You're to continue to provide court with proof of your local address, and you're to contact the probation department within 72 hours of your release. Your next court date on this probation violation is a revocation, arraignment, possible disposition hearing on March the 21st at 8:30. And that will take care of that matter. The second case, number 2 on the calendar, is another probation violation matter for a class 5 felony. The bond in that case has also been set in the amount of $500. The release conditions are identical, as is the court date of March 21st at 8:30. Lastly, the new case, you're charged with possession of narcotic drugs, a class 4 felony, possession of drug paraphernalia, class 6 felony, and assault, a class 3 misdemeanor. The court has found probable cause as to those offenses. I've also found you to be indigent in that case as well, and it's ordered to appoint you a public defender on that case. On this case, your bond is set in the amount of $1,000. It's a secured appearance bond. The release conditions are the same, only in this case there's an added, you have no contact with the alleged victims of any type. The other release conditions are identical. Your next court date on this case is slightly different. It's a status conference on March the 20th at 8:30 in the Superior Court in downtown Phoenix, with a preliminary hearing on March the 24th at 8:30. Do you have any questions about these three cases, ma'am?
No, ma'am.
All right. The officer will give you some paperwork. All right, we're going to take a short break while I do a DUI warrant. This is Commissioner Peterson, the AA Court. You ready to be sworn in on your warrant? Do you swear or affirm that the information contained in your warrant and affidavit is true and correct to the best of your personal knowledge, information, and belief? Okay, we'll grant it and it'll be in the portal in just a few minutes, okay? Yeah. Back, Miss Gooden. Miss Gooden would be followed by Nicholas Bouchard. Miss Gooden, if you could step up to the podium, please. Please state your name.
Amy Gooden.
And your date of birth.
8884.
Okay, ma'am, you're here on 5 different cases. Looks like 1 new case, 1 traffic case, and 3 probation violations. We'll take the new case first, number 9 on the calendar. On that case, you've been charged with theft of means of transportation, a Class 3 felony, possession of dangerous drugs, a Class 4 felony, possessing a weapon by a prohibited person, a Class 4 felony, possession of drug paraphernalia, and also possessing a weapon in the commission of a felony, both Class 6 felonies, and 1 misdemeanor count of failure to admit that you had a firearm. All right, the court has found probable cause as to those charges. The court's found you to be indigent. It's ordered appointing the public defender to represent you on that case. In that case, there's been a secured appearance bond set in the amount of $5,000. If you post the bond, you have no contact with any victim or witness of any type. You're not to initiate contact with any arresting officer. You're not to possess any weapons. You're not to possess any drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. You're to continue to provide court with proof of your local address and contact the probation department within 72 hours. Your next court date on this new case is a status conference on March the 20th at 8:30 with a possible preliminary hearing on March the 24th at 8:30. Number 11 is the traffic matter. It looks like a warrant out of Ironwood Justice Court on the charge of driving on a suspended license, a Class 1 misdemeanor. At this point, I'm not going to appoint counsel. That way up to the judge at the next court date. I've affirmed the bond that was set by the judge in that case of $500. So in that case, it's a $500 secured appearance bond. The release conditions are exactly the same, other than there's no victim in this case. Your next court date on this case is an arraignment hearing on March the 19th at 8:30 in the Ironwood Justice Court. All right, number 13 is your first probation violation for Class 4 felony. It's ordered appointing the public defender. On this case, I'm giving you a placeholder bond of $100. That way you're getting credit for that case as well. So, the release conditions are exactly the same, including contacting the probation department within 72 hours. Your next court date on the probation violation matters, on all 3 of the probation violation matters, will be March the 21st at 8:30 for a possible revocation. It will be a revocation arraignment hearing, possible disposition hearing. Number 14 You're on probation for Class 3 felony. Once again, a $100 bond. The release conditions are the same. Also, the March 21st court date. Number 15, you're on probation for another Class 4 felony. Once again, appointing the public defender. Once again, it's a $100 placeholder bond. The release conditions are the same, as well as the revocation arraignment disposition hearing on March the 21st. Do you have any questions about these 5 cases, ma'am?
No, sir.
All right, the officer will give you some paperwork. Good luck, ma'am. Nicholas Bouchard, followed by Eduardo Velez. Sir, please state your name.
Nicholas Bouchard, 82396.
Thank you, sir. Sir, you're here on 3 separate cases. First, number 3 is a new case in the Superior Court charging you with possessing dangerous drugs and possessing narcotic drugs, both Class 4 felonies, and possessing drug paraphernalia, Class 6 felony. The court's found you to be indigent. It's ordered appointing the public defender to represent you. On this case, you're not entitled to be released because you're on felony release for another matter. So in this case, at this point, you'll be held non-bondable. If at some point you're released, you're not to initiate contact with the arresting officers, you're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address. Because you're being held non-bondable, you actually have 3 court dates on this case. The first is a status conference on the new charge on March the 20th at 8:30 with a possible preliminary hearing on March 24th at 8:30. There's also an evidentiary hearing because when somebody's held non-bondable, they have to have an evidentiary hearing within 7 to 10 days to see whether or not they should be held non-bondable. So your evidentiary hearing is March the 21st at 1:30. That takes care of that. Well, that's your only case. I was looking at some other cases. Looked like they were connected. So this is your only case, sir. Do you have any questions? All right, the officer will give you some paperwork. I will take Mr. Valise somewhat out of order, and then Richard Catula. Sir, please state your name.
Eduardo Velez, always 1891.
Thank you, sir. You're here on 2 cases, both probation violation matters. The first case, number 32 on the calendar, you're on probation for a Class 4 felony. The court's found you to be indigent. It's ordered appointing the public defender to represent you. On this case, there's been a secured appearance bond set in the amount of $500 on the probation violation. If you post the bond, you don't have to have any contact with any arresting officers, possess any weapons, possess any drugs without a valid prescription. You don't have to drive without a valid driver's license. You must also submit to fingerprinting for this new charge and contact your probation officer within 72 hours. There'll be a number on the form that you'll get, which will have a way to contact the probation officer. Your next court date on this case is a probation revocation hearing on March the 21st, with a possible disposition hearing also on March the 21st at 8:30. Number 33 on the calendar. It's another probation violation for a Class 4 felony. Once again, it's ordered appointing the public defender to represent you. Your court dates are exactly the same, March 21st at 8:30, and your release conditions are also exactly the same. On this case, there's also a secured appearance bond of $500. Sir, do you have any questions about these 2 cases? All right, thank you, sir. The officer will give you some paperwork. Mr. Catula, followed by Anthony King. Sir, please state your name.
Richard Catula.
And your date of birth.
3/14/67.
All right, sir, you're here on a warrant out of the Desert Ridge Justice Court on the charge of leaving the scene of a accident with damage. It's a Class 2 misdemeanor. There's been a secured appearance bond set by the judge who issued the warrant at $500, so you have a secured appearance bond of $500. If you post the bond, you have you have to initiate contact with the arresting officers or any of the witnesses. You're not to possess any drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. You're to continue to provide court with proof of your local address. Your next court date on this case will be an arraignment in the Desert Ridge Justice Court on March the 19th at 8:30. At this point, I'm not appointing counsel. That will be up to the judge at the next court date. Do you have any questions about this case, sir? No. All right. The officer will give you some paperwork. Good luck, sir. Mr. King, followed by Carl Begay. Good afternoon, sir. Please state your name.
Good afternoon. Anthony King.
And your date of birth, sir.
1984.
All right. So you're here on a warrant from the Casa Grande Municipal Court on the charge of failing to appear in the second degree and disorderly conduct, class 1 misdemeanor. At this point, the court's not going to appoint counsel. The judge thinks it's appropriate the next court date they can do that. Your bond in this case is set in the amount of $250 as a secured appearance bond. If you post the bond, you're not to initiate contact with any arresting officers, possess any drugs without a valid prescription, or hold on, I'll give you a chance to say something. You're not to drive without a valid driver's license. You're to continue to provide court proof of your local address. Your next court date is March the 18th for an arraignment hearing in Casa Grande Municipal Court. Now, sir, what do you want to tell me?
I've got a court date here in Mesa on March 18th also at 8:30.
Okay. What you can do is, if they don't take you to Casa Grande, which they might not since it's out of county, when you go to Mesa, you can ask that court to contact the Casa Grande court. You'll have documents which will have the case number and everything else on it. Well, no, he has a different kind of release order. His release order is the one we did the.
No, that's
That's a different one. Okay, so you will have a release order which will have the information on it. When you go to Mesa, if you go to Mesa first, let them contact the Casa Grande court.
Okay. Do you know what date this happened on? The supposed.
Let me see if I can pull up the.
Right here, man.
Well, it's a 2017. It's a 2017 case number, sir. So it happened a while ago.
Okay.
All right.
Thank you.
You're welcome, sir. The officer will give you some paperwork. All righty, Mr. Begay, followed by Matthew Starcher.
Good afternoon, Your Honor.
Good afternoon, sir. Please state your name.
My name's Carl Paul Begay.
And your date of birth.
11/13/1988.
Okay. Okay, you're here, sir, on an out-of-county child support arrest warrant.
I tried to post bail on it, but I guess I got another case also here that I was unaware of.
Okay, well, in this case, they've asked for a cash-only bond of $100. I really have no choice but to affirm that. So it's a cash-only bond of $100 on this case. I've never seen a child support arrest. I used to do child support enforcement, but that's what Navajo County's asked for, and that's what I have to do.
That's totally understandable, sir.
All right, so it's a $100 cash bond. Your next court date on this will be an arraignment hearing in the Navajo County Superior Court on March the 19th at 8:30. You're not to have any contact with any arresting officers. You're not to possess any drugs without a valid prescription. You continue to provide court proof of your local address. I don't think I really answered any other questions you might have, sir, but I'll give it a shot. Do you have any other questions?
I got another court. Am I going to see you later today for that one, or?
Judge, yes, possibly for
They have their own separate court.
Okay, cool.
Okay, cool. Thanks, officer.
Thanks, sir.
All right, Mr. Sturcher, followed by Dave Miller.
Matthew Starcher, 3571.
All righty, sir. So you're charged with burglary in the third degree of class 4 felony, possession of burglary tools of class 6 felony, and criminal trespass of class 2 misdemeanor. I found you to be indigent. I've ordered appointing the public defender to represent you. On this case, I'm going to release you to pretrial services, which means you just have to keep in contact with them and follow their directions. You won't have to post a bond. You'll be released on this case. The officer will give you an envelope that has information about how to contact pretrial services. Make sure you keep that paperwork and contact them immediately upon your release, as well as keep the other paperwork because have your court dates. I'm going to give you some of your release conditions. Will all be in writing, but you're not to return to the scene of the alleged crime, which I believe was a dorm at ASU. You have no contact with any complainant or witness. Or you're not to initiate contact with any arresting officer. You're not to drive without a valid driver's license or possess any drugs without a valid prescription. You continue to provide court with proof of your local address. Your next court date on this will be March the 31st at 8:30, with a possible preliminary hearing to follow on March the 2nd at 8:30. As I indicated, all that will be in your paperwork. Do you have any questions, sir?
What does that mean?
What does what mean?
Pretrial services.
It's just an agency that you keep in contact with them. They'll tell you, they'll give you ideas of when your court date is. You just have to follow the directions. It beats sitting in jail on a bond.
Yes, sir.
All right? So step right over there, sir.
Appreciate it.
All right, Mr. Miller, followed by J. Walter Meyer. Sir, state your name.
Dave Miller.
And your date of birth.
2/26/61.
All right, sir. Sir, you're here on a failure to appear for possession of drug paraphernalia, class 1 misdemeanor. At this point, I don't have enough information to determine agency, so I'm not going to appoint counsel. Sir, the judge was requesting a bond, but I looked at your paperwork. It looks like you were going to try to take care of the situation, and I'm going to give you a chance to prove yourself on your own recognizance.
I appreciate it, Your Honor. I went to the wrong court.
All right. But you're going to be released on your own recognizance. Your next court date will be an arraignment hearing on April the 4th at 10 a.m. in the Moon Valley Justice Court. The information will be on the paperwork that the officer will hand you. Make your court date, sir. Otherwise, you're going to be back in jail. I'm almost done. Don't initiate contact with any arresting officers. No drugs without a valid prescription. Don't drive without a valid driver's license. Continue to provide court with the proof of your local address. Just make sure you make your court date, sir.
Thank you.
All righty. Mr. Walter Meyer, followed by Braden Twitchell. Sir, state your name.
Mr. J. Gary Waltermeyer, sir.
And your date of birth.
October 16th, 1970, sir.
All right. All right, sir, you've been charged with 3 misdemeanor offenses, 2 counts of disorderly conduct, class 1 misdemeanor, 1 simple assault, class 3 misdemeanor. I found probable cause on that. Your next court date is going to be in the Peoria Municipal Court on an arraignment on April the 3rd at April the 3rd at 9 a.m. I'm not finding you indigent at this point. I am going to release you on your own recognizance, but given the nature of this offense, you have no contact with the alleged victim while this case is pending. You may not reside in the same location as the alleged victim, even if you're the owner or renter of the residence. If it's a common residence, you're allowed 1 civil standby with law enforcement to retrieve essential belongings. You're not to initiate any contact with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address. Do you have any questions, sir?
Am I allowed to be in contact with my girlfriend that lives at the address, even though
she's the alleged victim of count 3. So at this point, no.
All right.
Once the case gets more along, I mean, it's a misdemeanor, it could be resolved fairly quickly.
All right. Thank you, sir.
All right. Step over here. Braden Twitchell, followed by Rakeem McNeil. Sir, please state your name.
Braden Twitchell.
And your date of birth.
10/19/2000.
All right, sir, you're charged with possessing dangerous drugs, class 4 felony, possessing drug paraphernalia, class 6 felony. The court has found probable cause. On this case, sir, I'm going to release you to pretrial services, which means you see keep contact with them and follow their directions. You will be given information about how to do that. Some of your release conditions include not to initiate contact with any arresting officers, not to possess any drugs without a valid prescription, not to drive without a valid driver's license. You continue to provide court proof for your local address. Your next court date on this will be a status conference on March the 31st at 8:30, followed by a possible preliminary hearing on April the 2nd at 8:30. And I think I mentioned it, but if not, I have appointed the public defender to represent you. Do you have any questions, sir?
No.
All right. The officer will give you some paperwork.
Thank you.
You're welcome. All righty, Mr. McNeil, followed by Morris Woods. Sir, your name, please.
Rakeem McNeil.
And your date of birth, sir.
January 10th, 91.
All right, sir, you've been charged with possessing dangerous drugs, class 4 felony, possessing drug paraphernalia, class 6 felony. I have found probable cause on this offense. I found you to be indigent, ordered appointing the public defender. On this case, you are going to be released to pretrial services. You'll need to keep in contact with them and follow their directions. You're not to initiate any contact with any arresting officers, possess any drugs without a valid prescription, or drive without a valid driver's license. You're to continue to reside in an address you provide the court. Your next court date will be a status conference on March the 31st at 8:30, with a preliminary hearing on April the 2nd at 8:30 in the Superior Court in downtown Phoenix.
Okay.
Do you have any questions, sir?
No, sir.
All right, the officer gives...
So y'all gonna, like, how to do that?
There's an envelope they'll give you with information about how to contact pretrial services.
Okay. All right, thank you.
Thank you, sir. All right, Mr. Woods. Let's just knock this one out real fast.
Good afternoon, Your Honor.
All right, good afternoon, sir. Your name?
Morris Woods.
And your date of birth?
3/11/1992.
All right, sir, you've been charged with taking the identity of another, class 4 felony, criminal trespass, a class 3 misdemeanor, simple assault and disorderly conduct, both class 1 misdemeanors. I found probable cause as to these charges. At this point, I find that you are not indigent, not eligible for public counsel. You are going to be released to pretrial services, which means you need to keep in contact with them and follow their directions. You will give them information about how to do that. Some of your release conditions are you're not to return to the scene of alleged crime. You'd have no contact with any victim or witness. You're not to initiate contact with any arresting officer. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address. Your next court date will be a status conference on March 31st at 8:30, with possible preliminary hearing on April the 2nd. The envelope will have information about how to contact pretrial services. Make sure you contact them and make your court date. Sir, do you have any questions?
No, sir. Thank you.
All right, sir. All right. Do we have a Swahili interpreter on the line?
Yes, Your Honor, I'm here. I'm a Swahili interpreter.
Deal. Okay. I'll ask you to begin interpreting now. Sir, please state your name.
Naomba useme jina lako.
Ndio.
Sema jina lako.
Lizama Elia.
Okay.
Lizama Elia.
Yeah.
All right. And is your date of birth January the 1st of 1973?
Nilizaliwa tarehe 1 mwezi wa kwanza 1973.
Ndio.
Yes.
Sir, you've been charged with criminal trespassing and class 5 felony.
Unashtakiwa kwa makosa matano.
Resisting arrest, a class 6 felony.
Kukataa kushikwa, hiyo ni kitengo cha 6 cha kosa.
Ndio. And consuming alcohol in public, a class 2 misdemeanor.
Kunywa pombe hadharani ni kosa kitengo cha 2.
I have found probable cause as to these offenses.
I'm sorry, Your Honor, repeat.
Okay. I have found probable cause for these charges.
Nimeona hasa sababu inayosababisha matatizo haya.
I have appointed the public defender to represent you.
Nimekutafutia mwanasheria wa kukusimamia na kukutetea.
Ndio. You are going to be released on your own. you are going to be released on your own recognizance, which is your promise to appear in court.
Tutakuacha, lakini uahidi ya kwamba utakuja mahakamani utakapoitwa.
Ndio.
Yes.
You are not to have any contact with any arresting officers.
Hautakiwi kuwa na karibu na maofisa wowote.
You are not to possess any drugs without a valid prescription.
Hautakiwi kukiuka masharti yote ambayo umepewa.
And you to continue to provide court proof of your local address.
Unatakiwa kuendelea kukaa pale ambapo unaishi na kuthibitisha kwamba unakaa hapo.
Ndio.
Your next court date will be a status conference on March the 31st at 8:30.
Unatakiwa kurudi mahakamani tarehe 31 mwezi wa 3 saa 2:30.
Ndio.
Yes.
With a possible preliminary hearing on April the 2nd at 8:30.
Uwezekano wa kuwapatia masikilizo mahakamani utakuwa tarehe 2 mwezi wa 4 saa 2:30.
Okay.
Okay.
The court will be in downtown Phoenix. The address will be on the paperwork you'll be given.
Mahakama itakuwa pale mjini Phoenix. Adresi itakuwa imeambatanishwa kwenye karatasi zako utakapoagwa.
Okay. Do you have any questions, sir?
Una swali lolote?
Hakuna, ni kutimiza hiyo mapashwa.
Unasema?
Ni kutimiza hiyo hizo saa zenyewe anasema kwangu.
No, I'll just watch on the time that I'm supposed to come.
All right. The information will be on the paperwork. All right. Good luck to you, sir.
Maelezo hayo watayaweka kwenye karatasi na kutakia kila la heri.
Thank you for interpreting for us, madam.
You're welcome, Your Honor. Thank you for using our service. Is there anything else I may help you with?
No, you're good to go.
Thank you.
All right, we have 2 house calls. Natalie Perez, number 18. The court's inclination at this point is to release Ms. Perez on her own recognizance. Mr. Roman Blancas, the court's inclination is to set a secured appearance bond in the amount of $5,000. If the court makes any decisions other than what I've indicated on the record, the court will come back on the record and issue any corrections. With that, the court will be in recess until the 5 p.m. calendar. Please be seated. All right, this is the 5 p.m. calendar for March the 15th. The court's orders for the taking of fingerprints and DNA samples made on the first calendar of the first day of the month apply to all hearings on this calendar. All right, first we're going to take Chelsea Dottenham. Please tell me your name and date of birth.
Chelsea Dottenham, 4/10/1998.
All right, we have counsel on the line for both the state and the defendant. Let's hear from the state's appearance first.
Thank you. Good afternoon, Your Honor. Stephen Garcia on behalf of the state.
Good afternoon, Your Honor. Stephen Duncan appearing on behalf of Miss Dottenham.
All right. We're here. You're charged with a number of counts. The first count listed on the charging document was aggravated assault with a dangerous instrument, a Class 2 felony. The court did not find probable causes to that count. You're also charged with 2 counts of aggravated assault, Class 3 dangerous felonies. The court did find probable cause on that count. Also on the aggravated assault to a first responder, Class 4 felony, endangerment and reckless driving. Does the state want to be heard on release conditions first, then I'll hear from Mr. Duncan?
Your Honor, just in short, I think defense is aware, but I can't speak for them. The state is asking for a $15,000 secured appearance bond. Nothing additional to add to my written recommendation. Thank you, Your Honor.
Thank you, Mr. Garcia. Mr. Duncan?
Yes, Your Honor, I've reviewed the state's written recommendations, and we are, for the most part, in agreement with the state's recommendation, but for 2 things. We believe that Ms. Dottenhahn is entitled to release to pretrial services, and we don't believe that the ankle monitoring requested is necessary. There's no evidence that she is a flight risk. She lives here in Arizona with her boyfriend. She's lived here for 5 years. She's got family, an aunt and uncle here who are very supportive. No history of drug or alcohol problems at all, and no prior arrests or FTAs. Notwithstanding, Your Honor, that she does have a very long mental health record since she's been 15 years old. She's 26 now. She has no offenses, though. Her last hospitalization was a year ago for 2 weeks, and this is the first known offense related to her mental illness. The police did take her to Banner, but the family is looking for a facility for her to get into as soon as she's released. She does have strong family support, and at the time this happened, she was calling her boyfriend and her friends for help to take her to the hospital. Her boyfriend arrived shortly after she left the house to take her, unfortunately, and her family has retained private counsel. So I would ask, Your Honor, to not order the bond, but release her pretrial services and not require ankle monitoring.
Thank you, Mr. Duncan. Having reviewed all of the documentation in the court's file, I am going to set a secured appearance bond, not in the amount that the state was requesting, but I think some secured appearance bond is appropriate given the nature of the offenses and all of the other totality of the circumstances. I'm going to set a secured appearance bond in the amount of $5,000. If the defendant posts the bond, she will be subject to pretrial supervision with alcohol testing and monitoring. There's no ankle monitoring or anything like that, just alcohol testing and monitoring. Ma'am, I'm going to go over some of your release conditions. They'll all be in writing.
Okay.
You're not having any contact with any alleged victim or witness. You're not having any contact with anyone, like I said, a complainant or a witness. You're not to initiate contact with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address. You must submit to DNA testing and fingerprinting at the arresting police agency. You've retained counsel, so there's no need to appoint counsel. Your next court date will be a status conference on March the 20th at 8:30, with a possible preliminary hearing on March the 24th, also at 8:30, in the Superior Court at 175 West Madison. All of your release conditions will be in writing. The officer will give you a copy of them when you leave the courtroom. Is there anything else from you, Mr. Garcia?
No, thank you, Your Honor.
Anything else from you, Mr. Duncan?
No, thank you, Your Honor.
Thank you both for appearing. We'll be in recess on this matter. We're going to proceed the following matter for the remainder of the cases. We're going to call 2 people at a time. The first person will come up to the podium. The second person will sit in the chair by the door. The next matter we're going to call is number 4, Morgan Fennell, followed by Martin Bradbury. Sir, please state your name.
Morgan Fennell, 92806.
All right, thank you, sir. Sir, you've been charged with armed robbery, Class 2 felony, and promoting a street gang or assisting a street gang, a class 3 felony. The court has found probable causes to those offenses. It is ordered appointing the public defender to represent you. The release conditions that have been set in your case is a secured appearance bond in the amount of $75,000. If you post the bond, you have absolutely no contact with any victim or witness or complaining witness. You're not to initiate any contact with any arresting officers. You're not to possess any weapons. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address. Your next court date will be a status conference on March the 20th at 8:30 with a possible preliminary hearing on March 24th at 8:30. Do you have any questions, sir?
No, sir.
All right, the officer gives the paperwork. Good luck, sir. After Mr. Bradbury can come to the podium now, followed by Alex Cortez to the chair by the door. Sir, please state your name.
Martin Francis Bradbury.
And your date of birth.
December 8th, 1997.
Sir, you're here on 4 matters, 3 of which appear to be probation violations, 1 of which is a new offense. We'll take number 9 first on the calendar. And in that case, you've been charged with, let me just check one thing real fast. All right, yeah, this is a warrant. This is not a probation violation. All right, so in this case, you've been charged with possessing narcotic drugs, a class 4 felony, narcotic drugs, class 4 felony, drug paraphernalia, class 6 felony. I have found you to be indigent. It's ordered appointing the public defender to represent you. On this case, I'm affirming the bond that was set when the warrant was issued in the amount of $1,000 as a secured appearance bond. If you post the bond, you're not to initiate contact with any arresting officers, you're not to possess any weapons, you're not to possess any drugs without a valid prescription, or drive without a valid driver's license. You're to submit to DNA, you're submit to fingerprinting by the arresting agency, and you must contact the probation department within 72 hours of your release. Your next court date on this case will be a status conference post-warrant on March the 20th at 8:30 in the Superior Court in downtown Phoenix. Number 10, this is also a Superior Court warrant charging you with possessing narcotic drugs, class 4 felony, possessing drug paraphernalia, class 6 felony. Your secured appearance bond in this case is an amount of $500. The other release conditions are identical. Your court date on this will be a disposition hearing on March the 20th at 8:30 in the downtown Superior Court. On number 12, the 2022 matter, it's been charged with a probation violation for a class 4 felony and also for a class 6 felony. Once again, the public defender is appointed to represent you. On this case, the court requested a $500 cash-only appearance bond. The court has affirmed that. The other release conditions are exactly the same. Your court date on that is also a disposition hearing on March the 20th at 8:30 in the downtown Superior Court. Lastly, in the 2025 matter, you're charged, this is also a Superior Court arrest warrant. On that case, you're charged with possessing narcotic drugs and dangerous drugs, both class 4 felony, drug paraphernalia, class 6 felony, and failure to provide a true name. Once again, the public defender has already been appointed on your case. On this case, the judge also requested a $500 cash-only bond, so that's the bond. The other release conditions are the same. Your next court date in this case is a status conference on March the 20th at 8:30 and a preliminary hearing on March 24th at 8:30 in the downtown Superior Court building. Do you have any questions about these 4 cases? All right, the officer will give you some paperwork, sir. Good luck. All right, Alex Cortez, followed by Jerry Stewart. Sir, your name, please.
Alex Michael Cortez.
And your date of birth.
August 28th, 1993.
You're here on a child support arrest warrant. The judge set a purge or a bond amount in your case in the amount of $1,362. There are no other release conditions because this is not criminal in nature. So if you post that bond, you'd be released. No counsel being appointed because it's a civil matter. Your next court date will be a return or a status conference in the Superior Court at 201 West Jefferson on March 21st at 10 a.m. Do you have any questions, sir?
May I represent myself in the case in some sort of manner and request that the bond would be excluded from the case just because in my situation currently with my finances, I've been struggling very much, and the reason being that the purge had even occurred was simply just because I read the email wrong, thinking that it was December. I thought it was December 9th, but it was December 4th. I've been going through court with my child and his mother for quite some time. I've never once missed a court date.
Here's what we can do. I can't change the purge amount here. When you go to court on the 21st, you can explain your financial situation and everything else. The judge who issued the purge amount will be the one who's at that hearing. He can make it lower purge. He could do any number of things.
Yeah, no, I'm sorry, I must have worded that wrong. I was just requesting that I would be released so that way I can handle.
I can't release you on a child support arrest warrant.
Okay, so I would be here till the 21st.
Unless you paid the purge amount, yes.
Okay.
All right.
All right.
That's all I can do at this point, sir. The officer will give you the paperwork. Good luck, sir.
All right, thank you.
Jerry Stewart, followed by King Sandoval. Sir, state your name, please.
Jerry Stewart, Jerry Lewis Stewart.
And your date of birth, sir?
May 9, 1953.
All right, so you've been charged with one misdemeanor count of assault and 2 counts of aggravated assault on first responder or law enforcement officers. The court has found probable cause as to those charges. On this case, there's been a bond amount set in the amount of $1,000. If you post the bond, you're not to initiate any contact whatsoever with the victim of the misdemeanor assault. You may not reside at the same location as the alleged victim, even if you are the owner or renter of the residence. If you have a common residence with the victim, one civil standby with law enforcement will be permitted to retrieve essential belongings. Once again, if you post the bond, no contact with the victim, not returning to the scene of the alleged crime, no initiating contact with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address and submit to fingerprinting at the arresting police agency. Your next court date will be a status conference on March the 20th at 8:30 with a preliminary hearing of March 24th at 8:30 in the Superior Court in downtown Phoenix. Do you have any questions, sir?
Yes.
No, actually, the county attorney requested a bond of $5,000. I think that was excessive, but a $1,000 bond, given the nature of the charges, especially in response to the law enforcement agency, is entirely appropriate. So the bond will remain at $1,000 at this point.
Well, I'm saying here to court here, right?
Yes, and then your attorney could file a motion to modify release conditions at that point, but at this point, your bond has been set. All right, the officer will give you the paperwork soon. King Sandoval, followed by Jasmine Sproul. Sir, your name, please.
King David Sandoval, date of birth 9999.
All right, sir, you're here on 2 separate cases. First, number 6 on the calendar is a probation violation for a Class 3 felony. It's ordered appointing the public defender to represent you. At this point, a cash-only appearance bond has been set pursuant to the court's order. It's $2,500. If you post the bond, you're not to initiate any contact with the arresting officers. You're not to possess any weapons. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You must submit to DNA testing. You must submit to fingerprinting at the arresting police agency. On number 7 on the calendar, it's a probation violation for Class 6 felony. On that case, there's been a $500 bond set. The other release conditions will remain the same. Your next court date on that is a probation revocation disposition hearing on March 21st at 8:30 in the downtown Superior Court. So your next court date on both is March 21st. Do you have any questions, sir? All right, the officer will give you some paperwork. All right, Ms. Sproul, followed by Zachary Adams. Please state your name.
Jonathan Prosper,
And your date of birth.
11/18/97.
All right, you're here on 3 separate cases. The first is a new charge of hindering prosecution, a Class 5 felony. The court's found probable cause as to that count. The court's appointed the public defender to represent you. Bond in that case has been set in the amount of $2,500. If you post the bond, you're not to initiate any contact with the arresting officers. You're not to possess any weapons. You're not to possess any drugs without a valid prescription. You're not to drive without a valid driver's license. You continue to provide court with proof of your local address. And you must contact the probation department within 72 hours of your release. Your next court date on that is a status conference on March 20th at 8:30 with a possible preliminary hearing on March 24th at 8:30. On the first of your probation violations, number 18, this is actually a Superior Court bench warrant. It's not a probation violation. It's a bench warrant. On this case, I've appointed the public defender. Bond has been set in the amount of $500. Other than that, the release conditions are the same. Your next court date on this case is March 24th at 9:30 for a status conference. Lastly, number 19 is a probation violation. Your court date, your bond on that is also $500. The release conditions are the same. On that case, your court date is a probation revocation on March 21st at 8:30 with a possible disposition hearing at the same time. Do you have any questions about these 3 cases, ma'am? All right, the officer will give us paperwork. Good luck. Mr. Adams, followed by Emily Evans. Sir, please state your name.
Zachary Adams.
And your date of birth.
August 10th, 1992.
All right, sir, you're here charged with failing to appear on a Superior Court warrant on the charge of possessing dangerous drugs. Bond has been set in the amount of $1,000 as a secured appearance bond. If you post the bond, you're not to initiate contact with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address, and you must submit to fingerprinting at the arresting police agency. Do you have any questions about this case, sir?
Yes, Your Honor. I had no idea about this. I don't want to take too much time, but I literally am on the way. It's been 2 days since I've used fentanyl, and I'm on the way to Vogue detox. I was on the way getting my health insurance set up. I finally got that going. There's a lot of hoops I had to jump through. That's not your responsibility. It's nobody's but mine. But I'm in a good momentum to go to rehab. I've struggled going. That is the plan. Immediately after this, I'm hoping we could release me and I could provide proof to the courts wherever I have proof that I'm going to either Vogue or Buena Vista detox.
All right, here's my problem, sir. You were released to pretrial services once before on October 21st on the 8 a.m. calendar. You were ordered to release to pretrial services, so the judge did not make you post any bond at all.
Yes.
He released you to pretrial services. According to the information, you didn't report to pretrial services and you didn't go to court. Generally, if somebody does something at a lower level, you don't reward them by either releasing you on your cognizance or doing exactly the same thing when you've already shown them that you wouldn't follow the directions.
You're 100% right. I without trying to comment, I did contact pretrial services. I was homeless at the time, and my phones kept getting stolen. I know it sounds like a bunch of excuses. I was wrong.
Well, you've had 5 months since.
Yeah.
So, sir, the current release, $1,000 bond is actually...
It's low, yes. So I'm desperate to get to rehab, and I've never been this desperate before.
Okay. Well, you can bring that up with the court at your next court date, but I can't do anything lower than what I've done, given your history of failing to appear on this case. So your court date is a status conference on the 20th and preliminary hearing on the 24th. The officer will give you some paperwork, so good luck.
Yes, sir. Thank you.
Okay, Miss Evans, followed by Michael Sanders. Ma'am, state your name, please.
Emily Evans,
And your date of birth.
10/6/77.
Ma'am, you're here on a warrant on the charge of possessing dangerous drugs, a class 4 felony from the Superior Court. You've already had the public defender appointed to represent you. I'm affirming that. On this case, the court set a secured appearance bond in the amount of $1,000. If you post the bond, you're not having initiate any contact with any arresting officers, possess any drugs without a valid prescription, or drive a motor vehicle without a valid driver's license. You're to continue to provide court with proof of your local address. Your next court date will be a status conference, post-warrant status conference on March 25th at 8:30 in the Superior Court in downtown Phoenix. Do you have any questions, ma'am?
Is there any possible way that I could be released to pretrial services? The only reason why I ask is the reason why I missed the court date to begin with is because I wasn't established with living. I was homeless, and I have established living. I rent a room from a gentleman, and I take care of him as well. So I would be putting my home in jeopardy, which is my fault. But
I understand that, ma'am, but once again, you're almost in exactly the same situation as the gentleman who was just here. I'm looking at your court record. You were released on your own recognizance, and then you don't show up. And you've been on warrant status for a year and a half. So you've had plenty of time to take care of the warrant. Cases don't just magically disappear.
Right.
So given all the situations, a $1,000 bond is as low as I can go on somebody who's was ordered by the Superior Court to be somewhere and just ignored it. So the bond will remain in effect, ma'am. All right, you can bring that up with your attorney at the next court date, but at this point, the bond is appropriate.
Okay, so it's $1,000.
Yeah, it's a secured appearance bond. It's not a cash-only bond. It's a $1,000 secured appearance bond.
Okay.
All right, the officer will give you some paperwork, ma'am. Good luck.
Thank you.
All right, next will be Michael Sanders, followed by Shayla Black.
Definitely, Your Honor.
Good evening, sir. Please state your name.
Michael Sanders, 102774.
Okay. I'll check one thing, sir. All right, so you're here on a Superior Court bench warrant on the charge of possessing dangerous drugs, class 4 felony, possessing drug paraphernalia, class 6 felony. The legal advocate's already been appointed to represent you. On this case, I've set a secured appearance bond in the amount of $500. If you post the bond, you're not to initiate any contact with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address. Your next court date on this case is a status conference on March 20th at 8:30 with a preliminary hearing on March 24th. You have another case, number 24, on the calendar, which is another bench warrant from the Superior Court on the charges of possessing dangerous drugs and possessing drug paraphernalia, class 4 and class 6 felony, respectively. Once again, the legal advocate is appointed to represent you. On this case, there's also a secured appearance bond in the amount of $500. The release conditions are exactly the same, and your court date is also March 20th at 8:30 and March 24th at 8:30. Do you have any questions, sir?
I'm appointed attorney to represent me.
I've appointed the legal advocate. There'll be an attorney from the legal advocate's office at your next court date.
Okay,
and the reason that I hadn't appeared to court because my family were on the street homeless, and I was taking care of them. I didn't want them to my wife had been attacked once, and I don't want that to happen again. So that's why I'm trying to get everything set up and get us situated before I came to court. Okay. That's one reason why I did not appear.
This is like 3 in a row where we've had people who've been released on their own recognizance or to pretrial services and then didn't appear, and then want the court to do exactly the same thing that you've already shown you're not able to do. Instead of setting bond in the amount of $1,000 on each of your cases, I set it $500 in each of your cases. So that's as low as the court can go. So you just need to make sure you make your next court dates, and the officer will give you a second for. Good luck, sir. Your Honor. All right, Ms. Black, followed by Josiah Kelly. Please state your name.
Shayla Black.
And your date of birth.
March 9, 2003.
All right, you're charged with probation violation. It's a probation violation warrant for a Class 6 felony. The judge, when they issued the warrant, set a bond of $500. I'm affirming that. If you post the bond, you're not to initiate any contact with any arresting officers. You're not to possess any weapons because you're on probation for a felony. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address and report to your probation department within 72 hours of your release. Your next court date on this case will be probation revocation, possible disposition hearing on March the 21st at 8:30. And if I didn't state it already, I think I did, but it's ordered appointing the public defender. Do you have any questions, ma'am?
Actually, I do.
Go ahead.
I did appear to this last court hearing for that case. I got it able to be best the means of undesignated. I do have and I did go to probation, and I did go to the probation office down the road, but I don't believe that I have any of the paperwork on me. Is it still? If it was already changed, why would it say that I was that I violated it?
Because there was a warrant that was issued.
But I already had cleared that warrant because it was a bench warrant, correct?
It was a warrant issued on February 28th. I don't see any court dates that you've made since that court date. All right.
Okay.
So your next court date is, as I indicated, March the 21st. The officer will give you some paperwork, ma'am. Good luck.
Okay.
Josiah Kelly, followed by Aaron Gray. Sir, please state your name.
Josiah Kelly.
Okay. Sir, and what's your date of birth?
08/13/2002.
All right, sir, you're here on a Superior Court warrant on the charge of possessing narcotic drugs, a Class 4 felony. Public defender's already been appointed to represent you.
You said what again? The last part?
Well, hold on just a second. I'm going to check some. It is ordered appointing the public defender to represent you, so I'm appointing counsel to you. This is a case where they sent notice to an address, and with the charges, you've never had an initial appearance necessarily. The judge did set a bond when they issued the warrant of $250. That's a secured appearance bond. I'm affirming that at this point. If you post the bond, you're not to initiate any contact with any of the arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address. You must report, well, hold on, let me check one of these. Okay, those are the release conditions. Your next court date will be a status conference on March the 20th at 8:30 with a possible preliminary hearing on March 24th, also at 8:30. Do you have any questions, Mr. Kelly?
You said my bond amount was what?
$250.
I mean, I have to pay the whole amount?
It's a secured appearance bond, so no, you can pay less than that. Some bonding companies will, some don't want to do a bond under $1,000, but some will.
All right.
All right. The officer gives you some paperwork, sir. Good luck.
All right, thank you.
Mr. Aaron Gray, followed by Adam Martinez. Sir, state your name, please.
Aaron Gray,
And your date of birth.
August 13, 1994.
All right, sir, you've been charged with aggravated assault with a deadly weapon, a Class 3 felony, and misdemeanor assault as a Class 2 misdemeanor. The court has found probable cause. On this case, your release conditions have been set as a secured appearance bond of $5,000. If you post the bond, you're not to return to the scene of the crime. You have absolutely no contact with any victims or witnesses. You're not to initiate any contact with any arresting officers. You're not to possess any weapons. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address. I specifically did not appoint an attorney to represent you because the court does not find you to be indigent and entitled to a public attorney. Your next court date on this case will be a status conference on March the 20th at 8:30 with a possible preliminary hearing on March 24th at 8:30 in the Superior Court at 175 West Madison. Do you have any questions, sir?
Is it possible to get my bond lower?
Let me look at the situation.
Because I feel like I should, we're I'm the one that got attacked.
Well, I'm looking at your injury, sir, and I read the Form 4, the documents. So given the fact that you did seem to suffer some injuries, I am going to actually lower the bond. I still think a bond is appropriate. The county attorney is requesting a much higher bond than what the court is going to do. I'm going to set bond in the amount of $2,500. Everything else remains exactly the same as far as your release conditions, including no victim contact or any of that. So it's a $2,500 secured appearance bond. Your next court date, as I've already indicated, is March 20th with a possible preliminary hearing on March 24th. The clerk will print the new release order, so it's a $2,500 bond.
Yeah.
All right.
I just want to mention that I was attacked in my sleep.
I understand that, sir, but I've looked at all of the documents. And like I said, the bond I've set is actually much lower than what the county attorney is asking for and what my initial inclination was. So it is a $2,500 bond. The officer will give you the paperwork.
Thank you.
You're welcome. All right, Mr. Martinez, followed by Robert Gillespie. Sir, please state your name and date of birth.
It's Adam Martinez, 12/20/2000.
All right, sir, you're here on 3 cases. The first, number 29 on the calendar, is a charge out of the Buckeye Municipal Court, charging you with possessing drug paraphernalia, a Class 1 misdemeanor, and failure to appear, a Class 2 misdemeanor. At this point, based upon the nature of the charges, I'm not appointing counsel. I'm affirming the bond that was set at $250. It's a $250 secured appearance bond on this case. If you postpone, you're not having contact with any arresting officers. No drugs without a valid prescription, no driving without a valid driver's license. You're to continue to provide court proof of your local address. Your next court date on this case is an arraignment hearing on March the 19th at 1 p.m. in the Buckeye Municipal Court. Number 30 on the case is a charge of possessing narcotic drugs, Class 4 felony, and possessing drug paraphernalia, Class 6 felony, in the Superior Court. I have appointed the public defender to represent you on that case. On that case, there's been a secured appearance bond set in the amount of $500. Other than that, the release conditions are exactly the same. Your next court date on this case is a status conference on March 20th at 8:30 with a preliminary hearing on March 24th at 8:30 in the downtown Superior Court. Lastly, number 31 on the calendar is another charge of possessing narcotic drugs, Class 4 felony, and possessing drug paraphernalia, Class 6 felony. Once again, a secured appearance bond is set in the amount of $500. The other release conditions are exactly the same, and your court date is March 20th and March 24th, the same, in the Superior Court at 175 West Madison. Do you have any questions, sir?
Yeah, so if I were to post bail, what would be the total?
Total is 500 twice and 250, so total is $1,250 on all three cases.
But that's with not paying the 10%, or is that just?
That's a secured appearance bond, so you could pay the 10% through a bonding company.
Okay. One more thing I was told to ask about is pretrial services. I never had them before.
It's not. It can't happen. First of all, on the city court warrant, and it's not appropriate given all of the situations on the other two cases.
Okay. Yeah, I was just told to ask because we had just recently lost our house. You know what I mean?
Never hurts to ask, sir. You never know.
No, yeah. You know, I mean, you never do know unless you ask. But we're homeless right now. I have 3 kids out there whose mother works and won't be able to watch them. So it's kind of.
I understand that, but I also set bond actually lower than what was recommended, so I feel comfortable with the bonding. Sir, you need to step over, and the officer will give you some paperwork. Good luck, sir. Mr. Gillespie, followed by Marco Silva. Sir, state your name.
Robert Gillespie.
And your date of birth.
12784.
So you've been charged with burglary in the 3rd degree, class 4 felony. A possession of dangerous drugs, which on the dangerous drugs count I did not find probable cause. With the other counts I have. Unlawful use of means of transportation, class 6 felony, and possession of drug paraphernalia, class 6 felony. It's ordered appointing the public defender to represent you on this case. On this case, given your record, I'm going to release you to pretrial services, which you will need to contact them and do everything that they tell you to do. I'm going to give you some other release conditions. You're going to have no contact with any alleged victims or witnesses. You're not to have initiate any contact with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court proof of your local address. Your next court date on this case will be a status conference on March the 20th at 8:30 and a preliminary hearing. Strike that. You're going to be out of custody. So your next court date will be a status conference on March 31st. March 31st and a possible preliminary hearing on April the 2nd. That will be on your paperwork that you'll be given. It's important you contact pretrial services upon your release. You'll be given an envelope with instructions about how to do that.
Okay.
Do you have any questions?
I don't think so.
All right. The officer will give you some paperwork. All right, Mr. Silva, let me do the interpreter. Sir, state your name, please.
Marco Silva.
And your date of birth.
January 16, 2003.
All right, sir, you've been charged with DUI as a class 1 misdemeanor. At this point, I don't have enough information to determine indigency. If you're entitled to an attorney, that will be decided at your next court date. You're going to be released on your own recognizance. Your next court date will be an arraignment hearing on April the 1st at 9:30 in the White Tank Justice Court. Release conditions include not to initiate any contact with any arresting officers, no possessing drugs without a valid prescription, no driving without a valid driver's license, and continuing to provide to live and provide a proof of your local address. Do you have any questions, sir?
So do I got a bond or am I good?
You're released on your own recognizance on this matter.
So
that just means you promise to appear. You don't have to.
Okay. So I just appeared to my next court date.
Yep. If you don't, then there'll be a bench warrant. You'll be in jail on a much higher bond.
Okay.
If you want to make sure.
If I don't show up.
Yeah. To make sure you show up, you're good. On April 1st, the officer will give you the paperwork.
Appreciate you, man. You have a good day.
You too, man. All right. While you're waiting, let me see if I can do this. DUI.
Are you ready for him now?
No, we're waiting for an interpreter. I'm going to do a quick warrant. Okay.
Para conseguir un traductor, ¿ok? On the first one, and I go. You come up with a conversation. I did not get down without it.
Hi, Trooper. This is Commissioner Peterson, the IA Court. Are you ready to be sworn in on your warrant? All right, sir. Do you swear or affirm the information contained in your affidavit and warrants true and correct to the best of your personal knowledge, information, and belief? All right, we'll get this signed and we'll get it back in the portal really soon. Good luck, sir. All right, just let me know when we have an interpreter.
Right, one in there, no one's out, right, so I'm calling out the one.
Hello, this is Evelyn. I am your Lion Bridge Spanish interpreter, ID number 2481. I am ready for your instructions.
Great, thank you. You can start interpreting now as soon as I start speaking again. Sir, is your name Browder Chavez Lopez?
Sí. Señor, ¿su nombre es Browder Chávez López?
Sí.
Yes.
And your date of birth is March 12th of 2007, is that correct?
Y su fecha de nacimiento es marzo 12 de 2007, ¿es correcto?
Sí.
Yes. Yes.
All right, sir, you've been charged with aggravated driving under the influence of intoxicating liquor, a class 4 felony.
Señor, usted está recibiendo cargos por manejo agravado bajo la influencia de licor intoxicado en un delito de la clase 4.
Also 2 misdemeanor counts of DUI.
También un delito menor de cuenta como manejar bajo la influencia del alcohol.
1 count of reckless driving, a class 1 misdemeanor.
Un tipo de conducir sin cuidados es también un delito menor.
1 count of driving on a suspended license, a class 1 misdemeanor.
Un tipo de manejar con una licencia suspendida, esto también es un delito menor.
1 count of failing to stay at an accident scene, a class 1 misdemeanor.
Un tipo de permanecer en un accidente como un delito menor de clase 1.
And lastly, consuming alcohol in a motor vehicle, a class 1 misdemeanor.
Y por último, consumir alcohol en un vehículo motorizado clase 1, un delito menor.
I have found probable cause as to those offenses.
He encontrado causa probable de estas ofensas.
I have appointed the public defender to represent you.
He encontrado un defensor público para representarlo.
I am going to release you to pretrial services.
Voy a liberarlo para servicios de precorte.
That will include alcohol testing and monitoring.
Esto va a incluir pruebas de alcohol y monitoreo.
You must follow all of their directions and contact them immediately upon your release.
Debe seguir todas las direcciones y contactarlos inmediatamente después de que se le libere.
I'm going to go over some of your release conditions with you. They will all be in writing.
Voy a repasar algunas de sus condiciones para liberarlo. Todas estas van a estar por escrito.
You have absolutely no contact with any victim or witness in this case.
No tiene que tener absolutamente ningún contacto con ninguna víctima o testigo en este caso.
You are not to initiate any contact with the arresting officers.
No debe iniciar ningún tipo de contacto con los oficiales de arresto.
You're not to have any drugs without a valid prescription.
No debe tener ninguna drogas o prescripciones prescritas permitidas.
You are not to drink alcohol at all. You just turned 18.
No debe tomar alcohol para nada. Usted apenas acaba de cumplir 18.
You are not to drive without a valid driver's license.
No puede manejar sin una licencia que sea válida de conducir.
You continue to reside in the address you provide the court.
Tiene que continuar viviendo en la dirección que usted proporcionó a la corte.
Your next court date will be a status conference on March 31st at 8:30.
Su próxima fecha de corte va a ser de tipo conferencia el día marzo 31 a las 8:30.
With a possible preliminary hearing on April the 2nd at 8:30.
Para la posible audiencia preliminar en el día abril 2 a las 8:30.
Very important you make your court dates and stay in contact with pretrial services.
Muy importante que haga sus fechas de corte y que en la corte permanezca en contacto con sus servicios prejuicio.
The officer will give you an envelope with information about how to contact pretrial services.
El oficial le va a dar un sobre con información de cómo contactar a los servicios prejuicio.
Do you have any questions?
¿Tiene alguna pregunta?
No. All right, the officer will give you the paperwork. Good luck. Thank you for interpreting for us, madam.
Thank you so much for using our services. Have a great day. Bye-bye.
You too. All right, now, Marianne Buxton. Marlene Buxton.
The interpreter has... Goodbye.
See you later. Sir, your name?
Marlene Buxton.
And your date of birth, sir?
05/17/2007.
All right. Sir, you're here on a grand jury warrant, charging you with unlawful use of means of transportation, being a passenger in a stolen vehicle, Class 6 felony, and criminal trespass, a Class 1 misdemeanor. I have found you to be injured and disordered, appointing a public defender to represent you. On this case, the grand jury set a bond, a secured appearance bond, in the amount of $15,000. At this point, I have to affirm that bond, so your bond currently will be $15,000. This defendant is under the age of 18. The court has considered the factors contained in the Federal Juvenile Justice Delinquency and Prevention Act. The defendant is to be placed in the physical custody of the Maricopa County Jail until released pursuant to further order of the court. Sir, if you were to post bond, you'd have no contact with any alleged victim or witness. You're not having initiating contact with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court proof of your local address. Your next court date on this case will be a not guilty arraignment on March the 21st at 8:30. Do you have any questions, sir?
No, sir.
All right. The officer gives you good luck, sir. All right, we have two house calls. First, Mr. Coverly. My inclination at this point is for the defendant to be held without bond because he's on felony release, so he's non-bondable. On Mr. Miss Arzaga, the court's inclination is to set a bond in the amount of $500. If the court decides to deviate from their inclination, the court will come back on the record And so note. This concludes the 5 p.m. calendar. The court will be in recess until the 8 p.m. calendar. All right, we're off the record. All right.